to tell me, here's our recording. I want everybody to tell me one word answer only. One word answer only. What is an estate? What's the one what's the one word you think of when we think of an estate? One word. When you think of an estate, what is it we think about? And the other thing about private chats, this is a great way to make sure we're here participating. So when I ask to hear from you guys, I want to hear from everybody. If you don't know, guess or be honest and say IDK. But when I ask to hear from you guys, I expect to hear from everybody. That's that class participation thing. So is everybody in? One word answer only. When we think of an estate, the one word we can think of, the one word to tie to an estate is interest. An estate tells you the type of interest you have, the degree, the quantity, the quality, the type of interest. And specifically, we have two different types of estates, two different types of interest. And this is where we left off the other day. Please remember too, you guys, all PowerPoints are in the online learning system. So please don't feel the need. Some of you already make my hand hurt. Day one, you've already made my hand hurt trying to write down every single word in front of you right now. So remember, you have those options of the PowerPoints and the recording that might alleviate some of all the writing you're trying to do. So there's two different types of estates, meaning there's two different types of interest. The first type of interest is a freehold interest. That means that you have an ownership interest. You own it. We're going to talk about the different types of freehold estates. It would be way too boring to only have one type of freehold interest. So we're going to talk about the different types in just the next slide. The other type of interest we have, the other type of estate we have is an interest of possession. If you're a tenant, you have a leasehold interest. You have a leasehold estate. If you're a tenant or if you're a landlord, allowing somebody to live in a property that you own, those are kind of fun because they're dealing with both types of estates all at once, right? The landlord owns it, they have the freehold interest, and then the tenant has the leasehold or the possession interest. We're going to get into the landlord-tenant relationship, and that's in Unit 11. So we'll talk about that leasehold estate and the different types of leasehold estates then. So hang on to that for now. And right now, let's just talk about our freehold estate. And I want you guys to turn with me in your books to page 29. Figure 2.4, we have a nice chart, a nice handy dandy chart there. And we can take our estates of interest and we can actually divide them into two categories. There's an estate of inheritance and there's an estate not of inheritance. So freehold estates are either inheritable or they're not. Inheritance doesn't kick in until the owner passes away. So when the owner passes away, can they be inherited or can they not? So we got the breakdown of what is and is not inheritable. And we're going to talk about each of these different types of freehold estates. So the first type we have, first up, is our fee simple absolute. This is the highest form of ownership. As real estate agents, this is the type of interest, the type of estate that we deal with the majority of the time. And when I say the majority of the time, I'm talking like 99 out of 100, for example. You very well may not deal with anything in your entire career, anything than a fee simple absolute. This is what we see most often. So it's the highest form of ownership, as we talked about the other day when we defined land. You own the land, you own the air rights above unless they've been severed, you own the subsurface rights below unless they've been severed. That fee simple absolute is the highest form of ownership, and you don't have any limitations on what you own. There are no limitations on use or time. The other freehold estates that we're getting ready to look at have limitations on use or time. But fee simple absolute has nothing, has no limitations on use or time. Now, here's the good news. Anytime in your career that you do get the opportunity to deal with one of these other types of estates, freehold estates that we're getting ready to talk about, this is a CYA topic. Does anybody know what that means? CYA. It had gone several different forms, but in this case, CYA is referring to call your attorney, or better yet, call your seller's attorney or your buyer's attorney. Anytime in real estate that we are dealing with anything that's not fee simple absolute, we got to get attorneys involved. It's turned into a legal matter. You and I are not in law school. We're not here to be attorneys. We can't act like attorneys. Remember, we said we're teaching you guys to stay in your lane. So if you get the opportunity to do one of these other estates, I think in some cases, we teach you guys just enough to be dangerous, but you need to know what you can handle versus what you need to turn over to an attorney, for example. And that's what I mean by stay in your lane. So as long as you're dealing with fee simple absolute, again, the majority of the time you may go through your whole career and only see these. If you ever get the opportunity to do anything other than one of these fee simple absolute, then you know that we're going to get our attorneys involved. So with that being said, we need a basic understanding of the other states so we know when to get attorney involved. We know what we might be dealing with. So there's a couple other types of freehold estates. Something called a fee simple defeasible, also known as a qualified fee estate. And with these, there's a restriction on the use. You know, when you buy one of these properties that you're restricted on how you can use the property. You're aware of those restrictions because they're in the deed. Now, we haven't talked about the deed yet, and we will. That's all coming in Unit 5. But the deed says what is the restriction on use. And you're aware of this when you buy it. So you buy honoring this restriction. And it's pretty simple. If you break the rules, you lose the property. If you violate the use, if you use it in a way that it wasn't intended, it wasn't allowed per the deed, you break the rules, you lose the property. So there's two different types of fee simple defeasible, two different restrictions on use. The first restriction is fee simple subject to condition subsequent. Who names these things, right? So the fee simple subject to condition subsequent. With these, you can do whatever you want to with this property within the confines of the law, except one thing. There is a restriction on one thing you can't do. Let's say, for example, that restriction is you can't serve alcohol. You can't serve it. You can't sell it. Let's say that. You can't sell alcohol. You can do whatever else you want to. There's no restrictions on that. The only restriction says is you cannot sell alcohol. The moment you sell one beer, you've broken the rules and you lose the property. Again, you knew going into it. The grantor is the person that gave you that property. So whomever you got it from, and if you break the rules in a fee simple subject to condition subsequent, if you do serve that one beer, for example, the grantor will take you to court and they'll get the property back. They'll stand in front of a judge and they'll say, they sold a beer, I put a restriction on it. They sold a beer and the judge is going to say, granted, we're going to take the property away from you and give it back to the person that gave it. So fee simple, subject to condition subsequent. One thing you can't do. The other restriction on use is a fee simple determinable. With these, there's only one thing you can do. You take this property, there's only one allowable use. Let's say, for example, the fee simple determinable, the deeded estate says this property can only be used for religious purposes. What's its one use? One and only use. Religious purposes. The moment you do something non-religious on the property, you've broken the rules. And this time, the grantor doesn't even have to take you to court. You break the rules and they're automatically going to get it back. When you guys see determinable, if I could take a play on words, can we see the word determine in there? Fee simple determinable has already been determined. If you break the rules, it's automatically going to go back to the grantor. Automatically going to go back to the person that gave it to you. They don't even take it to court. Common question I get, how do they know? Doesn't matter. Maybe they're keeping their eye on you. Maybe they know the neighbor and the neighbor's keeping their eye on you, right? Doesn't matter how they find out. Once they find out that you've broken the rules, you lose the property.
I have a question, Julie.
Yeah.
Does it, because do they take you to court, or do I have the right to take them to court? I mean,
In
because
this
it's already
case,
determined.
yeah, in this case, it's already been determined. We don't have to go to the court. It is automatic.
But
So
they
you
just
break
found
the,
out. There's no proof that it happened.
so if the two parties can't agree to agree, then we may have to go in front of a judge, right? So put real estate aside for a second, you guys. If two parties can't agree to agree, then yes, the judge has to decide for them. But if I call you up and I say, Regina, you did something non-religious on this property, and you go, I know, give me my deed back. It's automatic. You knew this going into it. And if you thought, well, I want to do something else, not religious, but I'm just gonna tell her, right? You knew going into this. Let's see. We got a couple of questions in the chat. Is this where land developers say strict build and has to be over square footage? Could be, Shauna. It could also have something to do with maybe just the covenants of the development, kind of the rules of the covenant. So absolutely, it could be a deeded restriction. These are deeded restrictions. So these are in regards to properties that are given and not bought. No, you buy this. You buy this. What's your ownership? What's your interest? I just gave you the answer. Did y'all hear what I just did? What's your interest? Your interest is that of an ownership. You own it. You just have restrictions on how you can use it. Let's look at an example together. I like examples. So the grantor, again, the one that gave it to you, deeds land to a school district, and in the deed it says, for so long as the school district maintains a public elementary school on the parcel, and if it ceases to do so, this estate shall end immediately. That's pretty dang clear, isn't it? Is there any uncertainty there? Is there any question? Well, maybe I'll lose it in 3 weeks, or maybe I can do something else maybe I'll put a middle school in. No, it's pretty specific, and these restrictions are specific. They need to be spelled out. So we can only use it for a public elementary school, and if we do anything else, it shall end immediately. This school district has a fee simple determinable estate. If at some point the district does not maintain the public elementary school, then the title to the land reverts back to the grantor. Another common question I get, what if that person has passed away? Then it'll go to their heirs. So the grantor or the heirs. And again, that's restriction. So fee simple, defeasible estates. And I would write that down real big. Fee simple, the feasible estates, two of them, there's a restriction on use, how you can use the property. Other types of freehold estates. We're going to talk about some life estates. We got several different types of life estates. And with life estates, these are restrictions on time. You own it, you have all the rights of the ownership, but you're limited to how long you own it. So what's the purpose of these restrictions? Maybe I'm a very religious person and this property has been in my family for years and years and years and years and years. And I cannot fathom the thought of anything. I can't imagine somebody buying this property and building a bar on it. Are you kidding me? This isn't what my family purchased this property for hundreds of years ago. So I want to preserve it. I want to keep it. I want to honor my family. So why would I put a restriction on it? And guys, you can put you're the owner of record. You could put a restriction of any sort. I could call an attorney today and have them draft up a deed for my property that has a restriction that says your front door can only be red. And anybody going forward will always have to have a red front door. And if you paint it anything other than red, guess what? You broke the rules. I get it back. They could mean something. They could mean nothing. The life estate then has a restriction on time. These are sometimes referred to as partial estates because they don't last forever. So we have three different types of life estates, three different types of estates that have a restriction on time. The first one is a conventional life estate. You own the property for as long as you're alive. This is one of our non-inheritable estates. You own it for your life. Once you pass away, the property either goes back to the grantor, back to the one that gave it to you, or it could go on to a named third party. Remember, these aren't heritable. So when you pass away, they can't go to your heirs. That's what we mean by not inheritable. So they're either going to go back to the person that gave it to you, or they're going to go on to a named third party. That named third party is in the deed. Once this conventional life estate is over, this property is going to go to Bob. Not inheritable. And as you guys are looking over, reviewing Unit 2, with all of these, there's examples. And always make sure you're looking at the examples in the book. Look out for those examples. They're good kind of strategies to help you better understand it. I like the for examples. I like the in practices. Another type of life estate is a marital life estate. This one is also not inheritable. We have two that cannot be inherited, the conventional life estate and the marital life estate. We're going to talk about how we own property in just a second. And one thing we're going to learn is that North Carolina is a spousal state. What this estate is referring to, though, a marital life estate is, and I'm going to talk about what that spousal estate means. But what this estate is referring to, let's say you own property before you got married. So you own property all by yourself, and then you got married. Because North Carolina is a spousal state, once you get married, your new spouse now has an interest in that property. Even though you owned it, you may not even have known your spouse when you bought it. But once you get married, North Carolina is a spousal state, and there's now an interest. And the marital life estate says that when that spouse that owned the property before marriage, if they pass away after we're married, how much is the new spouse going to get? How much is the surviving spouse going to get? They're going to use the length of marriage to determine how much you're entitled to. So you own property, you get married, your spouse is entitled to some of the property. How much? It depends on how long you were married. Again, more on spouses and what they own and what those rights are and all that good stuff coming up in just a second. This is also not inheritable. Because when that one spouse passes away, it's going to go to the surviving spouse and any heirs. It'll get divvied up that way. You guys see why I have you calling attorneys? Again, just introducing you to these topics, knowing when to get attorneys involved. So if you're dealing with a marital life estate, you don't have to use the length of marriage to determine how much they get. Not our job. Our job is to say, wow, you have a marital life estate. We need to get your attorney involved. That's our job, you guys. That's what we mean by I can't offer legal advice.
So in the event that the owner doesn't say what's going to happen with the property in the event they die, like, is this like?
Because we're a spousal state. So once you're married, there's an automatic interest. You don't have to say, my spouse should get some of it.
But what if you say, like, my spouse should get all of it? Or it doesn't work.
That's going to be up to the attorney. May have to draft the will, right, in a way that allows them, or maybe you could add them to the deed to protect that interest for them. Marital life estate is not inheritable. You're right. Thank you, Eleni. I apologize. It is not inheritable, which means what I mean by that is the one that can inherit it is the surviving spouse. It's going to be divvied according to the spouse that passed. How much you as a surviving spouse get depends on how long you were married. If that clarifies. Let's see. I think I saw a hand too. Yeah, Jennifer.
Did you say aside from fee simple estate, everything else is where you get the attorneys involved?
Correct.
Okay.
Does that make us feel a little bit better about this? What if you put the property in a trust? We're actually going to talk about trusts just a bit in this unit as well. Trusts are kind of the exception. So we will talk about that just a little bit. I'm getting the what ifs. Marital life estate says what? You own property, you get married, your spouse is entitled to something. What are they entitled to? It's going to depend on your length of marriage.
Julie, I know you didn't cover this one yet for the because I'm looking at the on page 17, no, sorry, 29. And under estate of inheritance, when it goes to freehold estate, then it goes to estate for the life of another. But that's the third one under the non-inheritance.
So that's my very next slide, Regina. Hang on 1 second with me. So our third life estate is life estate pour autre vie. You guys want your French lesson for the day? Pour autre vie means for life of another. And with a life estate pour autre vie, you have the owner, they own the property, they can do whatever they want to. They are going to own it for as long as the measuring life is alive. So there's a third party in this, and they are called the measuring life. They are the yardstick to determine how long you own the property. If you pass away, it can go to your heirs and their heirs and their heirs' heirs, as long as that measuring life is alive. That measuring life has no ownership interest. You're not going to find them on the deed. They are simply the yardstick to determine how long you own the property. When that measuring life passes away, the property either goes back to the grantor or it goes on to a named third party. There's a great, I love the example of this in your book on page 33. It says Austin owns fee simple title to a property. He conveys a life estate to his brother Carl for the life of Carl's daughter who has a major disability. Carl has the right to enjoy the ownership of the property, and he is the life tenant, but the daughter is the measuring life. Should the daughter pass, Carl's estate will terminate and revert back to Austin or Austin's heirs. The daughter has no present or future ownership in the property. She's just serving as the yardstick to determine how long Carl owns the property. Clearly, Uncle Austin wants a roof over his niece's head, right? He wants to make sure she has a place to live. He wants to make sure that she has somewhere safe to live. So he creates this life estate cooperative, and he says, Carl, I'll give you this property and you can have it. You can do whatever you want to, as long as the niece is alive. Once the niece passes away, it goes back to Austin or onto a named third party. I did not. Is it Kasia? I did not unless you sent it this morning. So I've been talking about going back to the grantor or onto a named third party, and both of those have official names. If it's going back to the grantor, then that's a reversionary interest. Again, if we can take a play on words and see the word reverse, the reversionary interest reverses. It goes back to the grantor. If it's going on to a named third party, that's the remainder man or the remainder interest. So there's a third party named in the will, said when this life estate is over, I don't want it back. Instead, I want it to go to so-and-so. If there's nobody named, then the default is to go back to the grantor. And again, if the grantor isn't with us anymore, then it'll go to the grantor's heirs. Remember, attorneys are drafting these deeds up. So when you're creating one of these, they're going to say, do you have a will? Do you have heirs? Well, if not, and you want it to go to your heirs, we need to take care of that too. Does that make sense? The attorneys know how to set these things up. They know how to address them. So at the end, they either go back to the grantor or their heirs, or they go on to that named third party. And these life tenants, these people that own the property, again, while they own it, they do whatever they want to it. It's theirs. They're only restricted on time. They're only restricted on how long they own. So they could earn an income from it. Some cases you might be able to put a tenant in place and collect rent. You want to plant an orchard and sell grapes? You could earn a profit from that. As long as zoning, covenants, again, nobody's allowed to break the law no matter what type of estate you have. You could use the property. You can't have waste. You can't damage the property, because with life estates, there's somebody in line after you to take the property. So you can't abuse it. You can't neglect it. You still need to maintain it to whatever standards we agree to. And because you're the one that owns it, well, you get to pay taxes and homeowners insurance and special assessments. We're going to talk about special assessments. So you have the rights of an owner. You're just restricted to how long. Again, you guys, that's some weird stuff, isn't it? I wasn't kidding when we came into Unit 2. I said, I got some weird stuff in here. We're not going to get, we saw a bunch of green stars. What do we remember about green stars? Green stars are level 1 stuff. We just need a very basic understanding. We could spend a whole lot more time on these if we were in law school. What we're addressing with you guys is, should you ever come across one of these in the real world, if you come across one of these out in the wild, we now know to say, whoa, this is a life estate. Let's get our attorney involved, teaching you guys just enough to be dangerous, but also teaching you when we need to get somebody else involved. And in this case, this is a call your attorney or call the attorney section. So very basic understanding. There was a great story I heard a couple years ago. gentleman said, I think it was said it was like his grandfather or something, grew up when he was a young man, he grew up helping an elderly couple maintain their property. So he would go over and help with minor repairs and yard work and blow the leaves, right? I mean, he was a very helpful person for this elderly couple. Unbeknownst to him, the elderly couple left the property to him in their will because he meant so much to them. He left the property and they left, and I don't remember what the restriction was, but they left a restriction. I think it was one of the ones on use. Said you can only use the property as this because they wanted to preserve it. They wanted to keep it how it was. So they created one of these life estates. He didn't even know he had it until they passed away. He got one of those calls from the attorneys that we sometimes see on TV, you know, your long lost great aunt so and so, and you're going, who, what? And all of a sudden you have property, you've acquired something. So these things, they're out there, they're not common. Like I said, you're going to go through, I'm going to say most of you will go through most of your career and never see this again. But we just need an understanding of what if you're the 1% chance that does. They're out there, so we're familiar with them. Questions? Let's take our first break. And when we come back, we're going to talk about ownership. We've talked about estates, we've talked about the interest. Now we need to talk about ownership. welcome back. So I'm going to take attendance. Let's talk about some different ownerships. We've talked about the estate. We know an estate is the interest. Now we need to talk about different forms of ownership. There are only two types of ownership. You either own it in severalty or you own it concurrently. If you own it in severalty, you are the sole owner. Severalty might be an individual person, it might be an entity, LLC, corporation, etc. So severalty is one owner. Look, here's a picture and everything. Severalty is one owner, sole owner. It is owned by a single person or entity. The other type of ownership is concurrent forms of ownership. Concurrent form of ownership is two or more. Could be two people, it could be 2,000 people, for example. There are several different types of concurrent forms of ownership that we're going to talk about. We're going to break each of these down. I tell you right now, Tennessee by the entirety is our form of ownership for people that are married. So I know I get a lot of questions about that, but we'll see that in just a second. But first off, we need to talk about Tennessee in common and joint Tennessee. So if you own Tennessee in common, again, you guys, this is another CYA. We can't create these types of ownerships. If you own Tennessee in common, typically speaking, your ownership interests are unequal. Maybe we buy this property 60-40, for example. Unequal ownerships. One thing we're going to learn with all of the concurrent forms of ownership is there's unity of possession. When I talk about we own it 60-40, that means your ownership interest is 60%, mine is 40%. When we go sell this property, that tells us how much we're going to get. You'll get 60% of the profit, I'll get 40% of the profit. Unity of possession says we can't divvy the property up itself. I can't draw a line down the middle and say, that's your 60%, and this is my 40%. You don't come on my 40%, I won't come on your 60%. That's what that unity of possession means. We have an ownership interest, which tells us how we can, what we get when we sell it. I think the best example of unity of possession I can offer you guys, did anybody growing up have to share a bedroom with a sibling? Had to share a bedroom, a couple of you. I'm an only child, so I don't feel that pain. But some of you tell me that when you had to grow up sharing bedrooms with a sibling, did you guys ever get in a fight and somebody would put tape down the middle of the room, or you put towels down the middle of the room and say, you don't come on my side and I'm not going to come on yours? Yeah, you can't do that with unity of possession. You can't do that. What we're talking about is you can possess the whole property. It's just your ownership. All three of them have it. That's right. Yeah, I didn't know those pains. So that unity of possession, each owner owns their own interest, so they can dispose of it however they choose. If you don't want your co-owners in a Tennessee in common to dispose of the property without your permission, then we need to have the attorney address that. But if it's not addressed, you have that undivided interest. And if you decide you want to sell your portion, your 60%, to somebody else, you can. One of the big difference in Tennessee in common versus joint Tennessee is what happens when the owner passes away. With a tenant in common, upon death, the interest goes to their heirs. So with Tennessee in common, ownership interests are unequal, and upon death of a tenant in common, their ownership interest goes to their heirs, divvied up between their heirs. So if we look at a picture, I got two people that own 60/40, a tenant in common. The 60% owner passes away. They have two people named in their will. So 30% of their interest will go to an heir, 30% of the interest will go to an heir. The one that owned 40 still owns 40. Their interest has not been affected. It's only the one that passed. Another form of concurrent ownership is joint tenancy. With joint tenancy, your interests are usually equal, 50-50, 33 and a third, 33 and a third, 33 and a third. We're going to talk about a few things in a second that make a joint tenancy a joint tenancy. And one thing to understand about joint tenancies is that in order to be joint tenants, we all have to show up at the same time. We all have to take title at the same time. You may be able to sell your portion. You may be able to sell your ownership interest to somebody else. That new guy cannot come in as a joint tenant because they weren't there when we all took title originally. I'm going to talk about what happens if they sell in just a second. So with joint tenants, in order to be joint tenants, we all have to be there at the same time on the same deed, taking title, taking possession at the same time. What happens if a joint tenant passes away? The answer to that is it depends. Other states, I don't know what states, but if you see joint tenancy on your national section, something called right of survivorship is automatic. In North Carolina, right of survivorship must be created. It's not automatic. So if right of survivorship is something you want in North Carolina, it's got to be added. So what is right of survivorship? Right of survivorship says if you have two people that owns, one of those people pass away, the interest automatically goes to the remaining owner. I don't care what this person's will says, doesn't matter, because joint tenancy says when one person passes away, the interest automatically goes to the remaining owner. We're getting ready to see right of survivorship again when we talk about married couples. So again, how do we answer this question? It depends on what section you're in. If you're in the national section, right of survivorship is automatic. If you're in the state section, we need to know, we need to see in the question that it's been added. It's not automatic, it needs to be created. So if we have right of survivorship, I got two people that own 50-50. Somebody passes away, one of the owners pass away. The remaining owner now owns 100%, and guess what? They now own in severalty. There is now only one owner, and they can dispose of the properties they want. The joint tenancy in this case has been destroyed. If you have 4 joint tenants and one passes away, then that 25% goes to the 3. When the other one passes away, their 33 and a third goes to the 2. When this one passes away, and it keeps going until you have that last man standing. That's right of survivorship. So let's look at an example. Sister and a brother purchased a beach cottage together. They took joint tenants with the right of survivorship. The brother later dies. His interest in the beach cottage automatically passes to his sister. But what about his will? Joint tenancies are going to override wills. We know that when you go into a joint tenant. So the brother passes, and now the sister owns it in severalty, and she can do with it whatever she wants. The joint tenancy has been destroyed. A characteristic of joint tenancy is that they have these 4 unities. There's our unity of possession again. You may own land 50-50 with somebody, but you can't draw a line down the middle of it and say, this is your half and this is mine. Unity of interest means we have equal shares, equal ownership interest, 50-50. Unity of time says we took title at the same time. Unity of title says we're on the same deed. So in order to be joint tenants, we have to have the 4 unities. Joint tenants may also be able to sell their ownership interest. They may be able to convey it. They may be able to gift it. So now the question is, what happens when the new guy comes in? So joint tenancy says if you have 3 or more joint tenants and one owner conveys their interest, the new guy must come in as a tenant in common. So let's say, for example, you have 3 owners and they each have an interest of 33 1/3. Let's pretend that that's even. And everybody's interest is 33 1/3. And we're going to call our owners A, B, and C. They had the 4 unities. They all came in at the same time. They all took title at the same time. They have unity of possession and they have unity of interest, 33 1/3. A, B, and C are all joint tenants together. Let's say B wakes up one day and says, I've had it with you guys. I'm done. I'm going to sell my interest. I'm going to convey my interest to D. D is the new guy. Can D be a joint tenant? You shake your head, yes or no? Can D be a joint tenant? No, because they weren't there when we took title. D's the new guy. He wasn't there when we took title. He's not there on the original deed. So D can't come in as a joint tenant, which means D now comes in as a tenant in common. What happened to the relationship between A and C? Nothing. Didn't affect them, right? So now I got a property that has multiple forms of concurrent forms of ownership. C, Y, A. This got out of our realm, you guys. What happens when D dies? What happens when A? We don't know because there's a lot of legalities going on. Again, if you bump into this, we got to get attorneys involved. That's their job. That's why they make the big bucks. My job is to help buyers and sellers, not to sort through with them how they own the property. Does that make sense? We're assisting them in transferring title. So D comes in. D's the new guy. D comes in as tenant in common. A and C still own the property. As joint tenants. Both tenant in common and joint tenancy, that's our TIC and JT, tenant in common and joint tenancy. How we end these, either the co-owners, all the owners, voluntarily agree to sell the property or sell their portion. Or if the court takes the land. When we get into Unit 5, we're going to talk about some times when the court may take the property. So if the court takes the property, no matter what type of ownership interest you have, the court's going to be able to. Have you guys ever heard of eminent domain? That would be the judge taking the property to use it for better use, maybe foreclosure, for example. Again, more on why the court would take the property when we get to Unit 5. The third form of concurrent forms of ownership is our tenancy by the entirety. And these are set aside for people who are married when they take title. So you're married, you got to buy a house, you're typically going to buy as tenancy by the entirety. Tenancy by the entirety is the default for married couples. They could still choose to do tenant common or joint tenancy, but the default for married people is going to be tenancy by the entirety unless otherwise stipulated by by the attorney. In order for a tenancy by the entirety couple to convey the property, they both must sign the deed. As we just said, North Carolina is a spousal state. What I mean by that, it takes one to buy, two to sell. Did you know you could buy property without your spouse? But hang on, before you run out and buy property without your spouse, you need your spouse to sell it. One to buy, two to sell. Spousal state. The story I heard in pre-licensing, a gentleman purchased a condo for his mistress. Did he need his wife's permission to buy a condo? Nah, he went out, bought a condo for the mistress. That relationship ran its course. It ended. He said, I'm going to sell the condo. Guess what the attorney said? Your wife has to sign to convey. That's what it means to be a spousal state. One to buy, two to sell. What are these guys' options? Well, I guess he either has to fess up or find a tenant or, right? But he can't sell it without his wife. That's what it means to be an investment or a spousal state. Somebody did ask about investment properties. This might be a little bit different because now you're a business or an LLC. So usually with tenancy by the entirety, married couples were like residential, for example.
I have a
So a couple
question.
questions about that. Yeah. Investment
Um,
properties are going to, or commercial properties are going to be a little bit different. Yeah.
would that also, like, if today I'm single and I buy a house and tomorrow I get married, and now I want to sell, would that be the option as well, the one to buy and two to sell?
Yeah.
Even if
Because
like I married him a month ago and I'm ready to divorce, he would have to have permission.
Yep. And there's only two answers to the question, are you married? Right? You either married or you're not. Y'all know that Facebook status, it depends. The courts don't recognize that. You either married or you're not. So if you let's Regina, great question. Thank you. So you own property and then you get married. First off, let's understand the act of getting married does not create a tenancy by the entirety. You've got to be married when you take title to be tenants by the entirety. Everybody with me? So the act of getting married does not create tenancy by the entirety. However, North Carolina is a spousal state. So now you're married, which means we need both of you to sell, even though your new spouse isn't on your deed. Now, there are such a thing as prenups. We're not getting into that. Big picture, reel it back to real estate. Tenancy by the entirety, one to buy, two to sell. With tenants by the entirety, right of survivorship is automatic. So you have two married people, one passes away, the interest automatically goes to the remaining spouse. I don't care what this person's will says. Tenancy by the entirety. One person passes away, right of survivorship is automatically. Tenancy by the entirety has the same unities as joint tenancy.
This also include like if you own a business?
Businesses may be different because now you're a corporation or an LLC. So these are
Okay.
going to be different. We're specifically talking about residential purchasing
Gotcha.
homes. Yep.
Okay.
Because your business, because you may be in business with 5 other people, right?
Yeah.
So is the spouse going to get something? Well, that's how that business arrangement is set up.
Gotcha. Okay.
Yep. Tenancy by the entirety is terminated by death of either spouse. Divorce would terminate tenancy by the entirety. The divorce decree is going to have to spell out what happens to the property when the divorce is final. Does one spouse get to keep it? Are we both going to keep it? And if we're both going to keep it, are we going to become joint tenants or tenancy and tenants in common? Or mutual agreements of the spouses. So if the two agree to sell, then that would terminate that tenancy by the entirety. We see some similarities with tenancy by the entirety and joint tenancy. And I think if it helps us to remember, joint tenancy was almost set up to mimic tenancy by the entirety for unmarried couples. If you and your significant other choose to go buy a home, you can't be tenancy by the entirety because you're not married. But however, you have the same union, the same relationship. You just don't have that piece of paper, right? So joint tenancy would be set up to mimic tenancy by the entirety for unmarried people. Here's the deal about the different types of ownership. I cannot tell anybody how to legally take title. That is the attorney's job. Another section that's teaching us just enough to be dangerous, but we need to know when. Let's say you are working with an unmarried couple and you're helping them buy a house. You know they can't be tenancy by the entirety. They need to decide if they want to be tenants in common or joint tenancy. Guys, we are not going to whip out our pre-licensing books and begin to attempt to explain the difference to these people. That's offering legal advice. Telling somebody how to take title is offering legal advice. So when you're working with that unmarried couple, we need to recommend that they talk to an attorney that can address with them how they should take title. And I feel like, bottom line, it's going to come down to, what do you want to have happen to your share when you pass away? Do you want it to go to the remaining owner, to the remaining significant other, or do you want it to go on to your heirs? And depending on that would help the attorney determine if we're going to do tenancy by the entirety or joint tenancy. Again, tenancy by the entirety is the default for married people. They could choose to do joint tenants. I don't know why, but that would be a conversation with them and their attorney. Maybe you're like Regina and you know you're going to get divorced in a month, so you don't want to take this property as tenancy by the entirety because you know that's getting ready to terminate. So you guys buy for some reason joint tenants. Again, attorneys are involved in all of this. And let's look at an example. While engaged, if you're engaged, are you married? No, you're close, but you're not married yet. While engaged, Tom and Nancy purchase a home in Walkertown. They are both named as grantees on the deed, receivers of the deed. Funnily, 1 month married, 1 month later they marry. That marriage does not convert the ownership to a tenancy by the entirety because they were not legally married when they took title. They bought the property before they were married. As a side note, once they get married, they could go to an attorney, have a new deed drafted up, and create a tenancy by the entirety. But it doesn't happen automatically. We have to go to attorney, we have to have a new deed, and it has to be created. Yes, ma'am, Victoria?
Okay, so since they weren't married, if they don't go and get that converted over to a tenancy by the entirety, then both of them aren't needed to sell the property. But if they do get it converted over, then they are both needed to make
So
a
if they
sale.
buy, let's say they buy, let's see, while they engage, they buy. So let's say they buy joint tenancy, right?
Mhm.
When they get married, because they're now married, both of them need to
Mhm.
sign that deed.
Okay,
1 to buy, 2 to sell. Specifically, the form of ownership wouldn't change from joint tenancy unless it happened through the process.
okay, but
But
either
North
way,
Carolina,
where
it's
there's,
always a spousal state. 1 to buy, 2 to sell.
okay.
Jennifer?
I'm sorry. Did you say again, if like I owned a house before I got married and then I got married, you could do the same thing with the deed and have it as a joint tenancy by the entirety, or I mean the tenancy by the entirety?
You'd have to create it though, yes. And
Okay.
that's the side note, because I think it's important that we understand that that doesn't happen automatically. We got to have an attorney draft up a new deed, create that tenancy by the entirety now that we are married. I did that. I owned a condo before I got married. I was young and single and I was tired of the roommate thing, right? So I went out and bought me a little condo. 10 years later, I got married. When we got married, that didn't create tenancy by the entirety. My husband would have now had to sign because now we're married. That's a question the attorney's going to ask you when you go to sell a house. Are you married? Because they want to know if you have somebody sign. I chose to create the tenancy by the entirety. So I conveyed it from me to us. And I chose to create the tenancy by the entirety. And the reason I did that, either way, he still has to sign because we're now married. But I chose to do that because if something happened to me, I didn't want him to have to go through more hurdles, more hoops. You know, now he's got to produce a death certificate, right? He just has more to do. So by me adding him to the deed, by me creating tenancy by the entirety for us, he and I are now seen through the eyes of the attorneys, through the eyes of the court as this ownership, this tenancy by the entirety. But again, we had to create it, or I had to create it. It didn't happen automatically. And that's exactly what my deed says. From Julie to Ryan and Julie. And it was just like that. There's a nice, and I have this for you in the online learning system, so you don't need to worry about writing it down. But I tell you this is here because again, this is one of these topics that we're getting ready to move on, but you may still see a test question on in May, right? So when you guys are coming back and reviewing everything, when you're taking it in, I like this little side-by-side chart, the side-by-side comparison to kind of summarize it. So you already have the slide in the online learning system that you can refer to. And again, you're going to see some similars, most of the similarities between joint tenancy and tenancy by the entirety. The big difference is married or not. Let's say, let's say grandma passes away and grandma leaves her property to all 5 grandkids. It's in her will. When grandma passes, the 5 grandkids are going to get the property. So grandma passes, it's conveyed to the grandkids. All 5 grandkids are married. How many owners do we have? How many people have to sign that deed when they want to sell it? I got to have 10 people show up. We got to have the grandkids and their spouses. Spouses may or may not be in the will. You with me? But because those spouses, because those grandkids are married, everybody has to show up. North Carolina is a spousal state. 1 to buy, 2 to sell. And if you're thinking about buying a condo for your mistress, now you know better, right? Moral of that story, just rent her an apartment. You can get out of that lease better than you can get out of the. No, don't have a mistress. I'm just kidding. Or a mister. So the will would be null and void, right of survivorship. One passes again. I don't care what this person's will says. You can't write a spouse out of your will with ownership. So one passes away, interest automatically goes. This is the person's will that matters. Because now what happens when this person dies, that's the person that's going to go, it's going to get the heirs. The last little piece of Unit 2 is talking about some common interest properties, also known as hybrid forms of ownership. They're hybrid because there's several different things going on. There's several different types of ownership going on. And also a common feature we're going to see in these hybrid forms of ownership is we might very well be dealing with a homeowners association, also known as an HOA, or a property owners association. We're going to talk about HOAs. We're going to get to those more in Unit 6. But for right now, an HOA is just going to be a property management, an entity, a company that's managing the property. So there might be a set of restrictions, covenants, for example, rules. The HOA is generally responsible for the common areas. So the common areas of the property. What are some examples? When we think about, for example, a condo or a townhome, this is where we're heading. What are some examples when we think of common areas? And you can tell all of us in the chat or just me, whichever. What do we think of with common areas? I got the clubhouse, absolutely, the gym, the fitness center, the pools, yeah, the playground, the park, the landscaping. Sidewalks, the parking lot. Yep, we got to have somewhere to park. The lobby. There you go. If you have a place with a lobby. So yeah, we're good. Those common areas are places where everybody in that community, everybody in that neighborhood shares. Elevators coming up from the lobby. Those are the common areas. And those are the areas that the HOA is responsible for. So a couple different types of hybrid forms of ownership. First up, we have our condo owners, condominium ownership. Condo owners only own airspace. Condo owners don't own air above. They don't own land below. Condo owners own, they say, from sheetrock to sheetrock, paint to paint. They only own interior. They don't own the actual building. They own the unit. And with a condo, the common areas are managed by the HOA. They're responsible for the upkeep, mowing the yard and keeping the pool up and the clubhouse and all that good stuff. They're managed by the HOA, but the unit owners own those common areas as tenants in common. So you have two forms of ownership. You own the unit, and then you're a tenant in common with the other owners for the common areas. Condo ownership, you may have exclusive right to limited common elements. Limited common elements, for example, might be your very own parking space, or maybe your very own garage or storage building. You have those exclusive rights to that element. Condo ownership is the only form of ownership that we can stack one on top of each other, because you don't own the air above. You don't own the land below. You just own your space. So we have a North Carolina Act, good candidate for a state-specific question. And we have something called the North Carolina Condominium Act of 1986. The Condominium Act of 1986 applies to the sale of the first unit of a new construction condominium. So the first one that buys it from the developer has to follow the Condominium Act. And if your buyer is buying a brand new condo, they're the very first owner. The Condominium Act says the developer must file a plat map. A plat map kind of gives us a lay of the land, a lay of the property, if you will. We're going to talk about plat maps in Unit 4. There also has to be a set of bylaws or rules, restrictions. The developer has to provide a public offering statement prior to signing the contract, prior to going under contract. That public offering statement discusses ownership structure, management. And a big thing that the Condominium Act says is that the buyer of the new unit, again, the very first person to buy this unit, has a 7-day recession period. If you rescind your contract, you are taking your contract back. You're canceling it. If you put down any deposits, you'll get your money back. So the very first owner of a new construction condominium has a 7-day recession period. which means they have time to review the contract. They have time to review the bylaws and the public offering statements. They have time to take this stuff to their attorney if they want and let their attorney look this stuff over. And if at some point in those 7 days they decide they're not happy and they don't want to buy, they rescind their contract. They take it back. If you put down a deposit, the developer has to give you your money back within this 7-day recession period. Both parties go about their lives as if this never happened. This only applies to new construction condominiums. The Condominium Act does say a few things about resales. So once that first owner sells it to the second, it becomes a resale. They still need to provide, the purchaser still needs to be provided the information about the property. Now they're going to be getting this resale certificate. What are the current HOA dues? Are there any outstanding special assessments, for example? The HOA, they put a special assessment on the condominium if we need to do, put down new roofs on all the buildings or repave the parking lot, right? Maintenance is required in the common areas. And when we need to maintain the common areas, the HOA will let the homeowners help them pay for it. And they'll do that through a special assessment. With resale, there is no right to cancel. You do not have a recession period. Another type of hybrid ownership, we don't see too much here in North Carolina, but another type of hybrid form of ownership is something called a cooperative ownership. You may have heard of a co-op. With a cooperative form of ownership, you don't own property. Cooperative form of ownership, you purchase stock. That stock allows you to live in a unit. You don't own property. You own stock. Your stock is personal property. But because you own that stock, you have the right to live there. I say we don't see much of these. I've heard of one in Charlotte, but I can't validate it. I can't verify it. I'll tell you where we see these. Think of our bigger, older cities. New York City, Boston, Philadelphia. These are much more common. So again, a co-op, you don't own property, you own stock. That proprietary lease is your occupancy agreement. The proprietary lease that's in exchange for you buying stock and you get permission to live there. Another form of hybrid ownership are townhomes. Townhomes are sometimes called row houses because they share a wall. With townhome ownership, you own a little bit of land above. You own the little bit of land below. Air above, that's not what I said. Air above, land below. You own a little bit of air and land. But you're attached, usually a party wall. A party wall means you both share a wall. You and your neighbor share a wall. So they're attached by that party wall, often called row houses. Townhomes can be 1 story, they can be 2 story, they can be 3. They're attached in the side of that party wall. With townhome ownership, the common areas are owned and managed by the HOA. Now I'm going to do a nice side-by-side comparison for you in just a second about condos and townhomes so we can see those differences. Townhomes also have the HOA with HOA dues, possibly special assessments if we need to redo the roofs or repave the parking lot. Some townhome communities, you're responsible for mowing the strip of land out front. Sometimes they'll have landscapers as part of the HOA dues that'll come in and do it. Townhomes are not subject to the North Carolina Condominium Act because they're not condos. So townhomes have similar act, the North Carolina Planned Community Act. They're not as heavily regulated as condos, but they do have a little bit of regulations. So to compare the two, condo owners, they own airspace. They don't own land. With condo owners, your common areas are managed by the HOA. They're owned by the owners as tenant in common. Townhome, you own land. Not a lot, but you do have land. And your common areas are managed and owned by the HOA. Questions on condos or townhomes? With the condos, are there a lot of fees you pay? Either one of them is going to have HOA dues. HOA dues vary from condo to condo, townhome to townhome. It's whatever the management company, whatever the HOA sets up. Sometimes those dues have to go up. But they're going to maintain, those dues are set aside to maintain the common areas. Some HOA dues are monthly, some are annually, some are quarterly. They're all different, and it all depends on how the developer creates them. When they create the condo community, they also create those rules, those HOA dues, etc. So I don't know about a lot of fees, but you will have some, and it's going to vary from community to community. There is in Unit 2, you know what, let me go ahead, because I always fear I forget to tell you guys this stuff. So I do want to point out, in Unit 2, in the online learning system, I put a Q&A brochure in here for you. We're going to see these Q&A brochures throughout the class in the online learning system. So I want to talk to you about them first off, where I get my information. These Q&A brochures come from the North Carolina Real Estate Commission. So they create these things. They make them available for us to use when talking to buyers and sellers about condos and townhomes, for example. They're also available, buyers and sellers, the public can go to the website and find these. Remember what we said the other day, you guys. What's the commission's #1 purpose? What's their main purpose? I can see mouths move. Protect the public. Yeah, and one way we can protect the public is by educating them. So they provide informative Q&A brochures, information, for example. We put them here for you guys to help you guys better understand. So they come straight from the commission. Remember, they're the ones giving you your state exam. So they come straight from the commission. Anything about condos and townhomes. This is just a good little informative document. If you guys will look this over, you'll everything you need to know about condos and townhomes and then some. But just always remember, with these Q&A brochures, they're written towards the public, but they're also helpful for you guys in understanding, better grasping this material. Questions on condos or townhomes? Yeah, Jennifer.
Well, what if you buy like an older condo? It wouldn't be protected under that act, right?
So you would still need to provide the information, what the dues are, how it's structured. That would be part of the sale. And then you're correct. You do not have a rescission period on a resale. So
Okay.
once it's sold the first time from the developer, it's no longer new.
Okay.
The last form of hybrid forms of ownership we have, common interest community, are timeshares. Timeshares are, they're pretty highly regulated in North Carolina. Timeshare developers have a reputation. Was it warranted or not? I don't know, but they do have a reputation of being a high pressure sales tactic. And so the commissions, remember, their main purpose is to protect the public. So to address some of these high tactic sales pressures, the Real Estate Commission, there's a Timeshare Act that regulates how timeshares are structured and how they are sold. So first off, the basic definition of a timeshare. The basic definition of a timeshare says it's the right to occupy a unit at least 5 or more times over at least 5 or more times over at least 5 years. I need you guys to note that at least 5 is the minimum. If you buy a unit for 4 separate time periods over 4 years, you don't have timeshare. So in order, step 1 to qualify as a timeshare, by the way, let me back up for a second. I might have got a little ahead of myself. With a timeshare, you own real estate, but you only have the right to occupy it, for example, 1 week during the year. So that 1 week during the year is when you have the right to go occupy it. You share that ownership with 51 other people. And when it's their week, they have the right to go, or 2 weeks or whatever. So you have that right to occupy at least 5 or more separate time periods over at least 5 years. With a timeshare ownership, the buyer under contract, the buyer considering purchasing it under contract, has a 5-day recession period. So we go under contract, the buyer has 5 days to decide if they want to move forward. Do they want their attorney to look over the contract? And within those 5 days, if they decide they don't want to purchase it, they rescind their contract, which means they take it back. If they put down any deposits, they'll get their money back. And both parties go about their lives as if this never happened. Again, that 5-day recession period with these, it's almost like a cool down. Again, we're trying to address those high tactic sales pitches that are often associated with timeshares, or have been in the past, I should say. The other piece about a timeshare is that the money, your deposit, when you contract, the developer is going to require a deposit, and that deposit has to stay in the developer's escrow account for 10 days. Now, I just said escrow account. We're going to talk about I'm going to dance all around the escrow account, but we're going to talk about the escrow account, also known as the trust account. That's coming. What we know right now is that developers got to keep it in their account for 10 days. If the contract's rescinded, then they are going to immediately refund that back to the buyer. If it's not rescinded on day 10, then the developer can transfer that from their escrow account to their operating account. But they got to keep it in their account for question comes in about being a new timeshare. No, this is new. This is resale. This is anytime we're selling timeshare. Could be a 50-year-old building, but the Timeshare Act is still going to apply because they're still managed and operated by the timeshare developer or one of their offsets. I got a little bit more to say about timeshares, but I do want to address, I think if you guys are going to get a test question about timeshare, it's going to be on this slide. So I want to make sure we're good on this. I do have a little bit more to say, but let's do something together. Let's do a little exercise together to help us remember what we need to know about timeshares. So push back, give yourself some room. I don't want you to punch your screen or anything. So push back, give yourself some room. And how we're going to remember timeshares, the big thing that we need to remember about timeshares is 5, 5, 5, 10. And for fun, let's throw in some jazz hands. Wasn't that fun? All right, let's all do that together. What do we need to know about timeshares? 5, 5, 5, 10. Jazz hands. You're not going to be tested on jazz hands, but if that helps you remember, why the heck not, right? That was kind of weak, you guys. What do we need to remember about timeshares? 5, 5, 5, 10. Jazz hands. This is the big thing that you need to know. And that's that 5, 5, 5, 10. Jazz hands. Jazz hands. Understand a few other things about timeshares. It doesn't matter what you call it. If you call it a vacation lease or a club membership or a limited partnership, the name doesn't matter. If it fits the definition of a timeshare, what's the definition? Basic definition, 5, 5, 5, 10. If it fits that basic definition, it is considered and treated as a timeshare. If it walks like a duck and quacks like a duck, it's probably a timeshare. Again, this helps keep these developers honest. Now, remember what we said, at least 5 separate periods, at least 5 years. So if you have 4 separate periods, 4 years, then maybe it is a vacation lease. Maybe it is a prepaid hotel. The whole point of this is so the developer doesn't try to trick the system by calling it a limited partnership and not being able to treat it like a timeshare. There's one more thing about a timeshare that we need to know that makes it rather unique. The North Carolina Real Estate Commission regulates our license. They can't fine most licensees. Timeshare is the exception. This is the only time that the Real Estate Commission will get involved with matters of money. If you're a timeshare developer, if you work for a timeshare corporation, not only can they discipline your license, but now they can also fine you. All other licensees in the state of North Carolina can't be fined by the Real Estate Commission. This is the only time they will get involved with matters of money. That disciplinary action, what they can do to your license, all that is coming. If you're getting fined as a licensee, it's from the court. It's not from the Real Estate Commission. Put real estate aside for a second. Anybody can sue anybody for anything, right? There's some crazy, crazy lawsuits out there. Could your buyers and sellers sue you after the transaction? Sure, you sue anybody for anything. How far are they going to get? I don't know. I don't know what their case is. I don't know. I do have advice for you guys. I want you to write something down for me really big. Everybody ready? I got 2 words. I want you to write down real big. We ready? Document everything. Document everything. If you do at some point in your career face disciplinary action, if you do at some point in your career find yourself being sued by your buyer or seller, your documentation is the only leg you have to stand on. What's that old saying? If you didn't document it, it didn't happen. You're not going to be able to stand in front of a judge or the Real Estate Commission and say, I didn't do it. They're going to need to see your documentation. Your documentation might show that you're guilty, right? I don't know. But if you're not, that's the only way you have to protect yourself. So what do we document? Everything. If you have a conversation with somebody face to face or over the phone that has substance, something to do about this transaction, I need you to go home and follow it up with an email talking about per our conversation, yada, yada, yada. That's how you document phone calls. That's how you document face-to-face conversations. Again, if it's something of substance, if it's something related to this conversation, that's how you document. Now you got an email with a date and a time stamp. that shows that you said what they're claiming you didn't say. Questions on timeshares? Great question. How long should you hold documentation? There's a commission rule that says we have to retain all records for 3 years. Minimum is the 3 years. Could you keep it for longer? Yeah. Commission rule requires 3 years. I'll be honest, you guys, we live in a pretty litigious society right now, don't we? People are suing everybody all over the place. You can keep it for more than 3. 3 is just the minimum. What's it going to hurt you to keep it for 10? You with me? People are loving to sue these days. The only way we can protect you is if you have that documentation. All right, let's go ahead and take our break. When we come back, I only have like one more thing to say in Unit 2. And then we're gonna do a little math introduction. So let's take 10. So cameras are on and they will stay on. I'm going to take attendance. I'm going to wrap up Unit 2 real quick. I'm going to talk about some math. The last little piece of Unit 2 isn't a hybrid. It's just, it's called a trust. Trust might be in a way for you to do your estate planning. It might be a way for you to set up your estate planning. So, you know, specifically how it's going to go, where it's going to go when you pass away. Trusts are often set up to avoid probate. Probate is the reading of the will, the dissecting of the will. Sometimes probate can get sticky, it can get messy, it can get expensive. You have conflicting interest. So an option might be to set up a trust. Obviously, you need an attorney to do this. This is another CYA. There's 3 parties with a trust. There's the grantor, the person giving the property. There's the beneficiary, the person that's receiving the property. And then there's that third impartial middleman referred to as the trustee. The trustee is going to be an attorney that is handling the affairs on behalf of the beneficiary once the grantor passes away. As real estate agents, let's bring this back home. If we are ever called to handle the sale of a trust, for example, then we are going to be dealing with the trustee. We are going to be communicating with the attorney. They're going to handle the sale. So you already got attorney involved if you're ever doing one of these. A lot of times in class, I get asked, how do I set up a trust? That's out of the scope. That's out of the realm of this class. And my answer to you is going to be, call your attorney. They can assist you in creating one of these. So you can make sure your wishes will be honored as you wish, and your family doesn't have to go through that probate. And that gets us through Unit 2. So as a reminder, you guys, you got the key terms at the beginning of Unit 2 on page 20. Use those key terms as a checklist. You know what this word means. You know what that word means. Not sure what this one means? Look it up. Guys, remember, you have a glossary in the back of the book. Also remember, you guys are learning a new language. We're teaching you how to speak broker. So if at any time you don't know what a word is, what a word means, please look it up. If it's not in the glossary, or you're not sure if it's in the glossary, you guys have a handy dandy tool at your disposal, don't you? Called Google. So anytime you come across a word, you don't know what it means, help you better understand that by looking it up. Key point review for Unit 2, the Cliffs Notes, is on page 43. And then there's that student quiz on page 47. A big part of Unit 2 is teaching us when we need to call an attorney, get an attorney involved. We're starting to teach you guys to stay in your lane and knowing when to call in the expert. So we're recording, but real quick, Tennessee in common, your ownership shares are unequal. When you pass away, your ownership interest goes to your heirs. Joint Tennessee, equal ownership. Whether and what happens to your interest depends on if you have right of survivorship or not. So I encourage you to go back and review the unit, the recording when it's available, so you can kind of see. And then you got that nice side-by-side chart, side-by-side comparison in the online learning system. Couple cameras. aren't on. I'm not sure if you're back from break yet or not, but if you did come back. I need to stop sharing just for 1 second. Bear with me. What we're going to do now, we're going to take a break from the book for just a second. And I have a math introduction. Now, I know some of us feel better about math than others. Remember what I told you guys on day one when it comes to the math. We're not going to stress out about this. We're not going to lose sleep over the math. Will everybody promise me? Right hand up. I promise I'm not going to lose sleep over the math. However, we do have some math to cover. We don't actually get into the math until the end of Unit 3. We'll see that next week. But I do want to introduce you guys to some of the basic concepts, basic ideas that we're going to be dealing with. And remember, you guys, if math isn't your thing, please take a few minutes in the back of your book and find the math FAQ section and refresh yourself. Revisit some of those more basic, like converting fractions to decimals and rates to percentages, that kind of thing, just to get yourself warmed up so we'll be ready when we do start the math at the end of Unit 3. This is fairly basic math that we're learning in this class, hence the basic calculator. And I know a lot of times what I hear from you guys, and hey, I get it too. It's hard to read the words and know what to do as far as formulas and maths goes, right? So when we're reading these math problems, we want to start looking for certain words. And when you're reading a math problem and you see the word of, that word of is telling you to multiply. So that word of is a good indication of something to multiply. So in other words, what we're saying, 350,000 times 25% is the exact same thing as saying 25% of 350,000. What does that word of mean? That word of means multiply. So why don't you guys go ahead and set your chats to private, if they aren't already, just to me. And in a private chat, and if you don't have a basic calculator yet, please use your phone today. But make sure you make a note before we meet again next week to get yourself a basic calculator so we can get you practicing on it. Everybody tell me in a private chat, what is 25% of 350,000? Your calculator on your phone is very smart. The basic calculator you use for exam, not so much. So a lot of us are probably accustomed to using the smart calculator. I want us to start using the not so smart calculator to get you ready for the exam. On the calculator on your phone, you could put in 25% times 350,000 and get the answer. Your not so smart calculator isn't that smart. So we have to start understanding how that's going to work. So on your not so smart calculator, we need to put in 350,000 times 25%. And that gives us 87,500. Order on your not so smart calculator matters. And that's why we got to get you. Some of us, it's been so long since we've used a basic calculator. How many of you use a calculator on your phone on the regular? On the regular, that's your go-to when you need a calculator. Yeah, I got to get you off that because your calculator, your basic calculator isn't that smart. Does that make sense? That's why I want you guys practicing on this thing now, because there's a whole lot more you can do here that you can't do here. So please go calculator shopping. I got you. I got you. So again, with your basic calculator, and again, if you don't have, you just have your phone today, use it for today, but we're going to go calculator shopping. Also tell me in a chat, there's a problem for you. So in a private chat, tell me about Lane. So when we see a math problem, when we see any problem, I don't care if it's math or not, when you see a problem, the very first thing I want you to do is stop and read the problem. Sometimes, oftentimes, specifically with math, when we know we need to calculate something, we are so quick to pick up our calculator. You may or may not know what it is you're calculating. So what I need you guys to do, the very first thing you do before you touch a calculator is just read the problem and ask yourself, what is this problem asking me? You know, earlier I talked about distractors. Math is one of their favorite places that they like to put distractors. So I'm going to encourage you guys to know the formulas. If you know the formulas, then you know what you need to solve that problem. You know what you need to solve it, and you know what's a distractor, which you don't need. They're going to give you more information than what you need to know. So we see the problem and we read it to ourselves. Lane sells her home for $250,000, pays her real estate agent's firm a commission of 5% of the sales price. What is the total commission paid? Commission is 5% of what? Of the sales price. What does the word of mean in a math problem? The word of means multiply. That's our action. That tells us what I'm multiplying by what. So on our not so smart calculator, we take the sales price of 5% of that sales price, and we get the commission of $12,500. What happens to that commission? How does that commission get divvied up? Who gets that commission? All the answers, everything you've ever wanted to know about your commission is coming in unit 12. Nope, 8. I don't know why I said 12. Unit 8. So we're going to talk about your commission, how you get paid, when you get paid, how much you're going to get paid. We will get to all of that in unit 8. Please bear with me. Questions on how I got the 12,500? So I have a math tool I want to introduce you guys to. I think if we can get this math tool, we can probably get a good chunk of this math. So I'm going to introduce you to my favorite tool with this math in this class. Is something called the T-bar. Please take a minute and write this down, and then we will talk about what this thing means. So with the T-bar, the T-bar is looking at 3 variables. something called the part, something called the whole, and something called the rate or percent. T-bar 101. The rate or percent always goes in the bottom right. Did you guys just hear my absolute word? Rate or percent always goes in the bottom right. You can take that out of your guesswork. You don't have to sit and stare at a question and go, oh, where's the rate or percent go? It always goes in the bottom right. Now we're left with the part and the whole. Generally speaking, when we're looking at these various problems, and I'm down to the two components, is this the part or is this the whole? Generally speaking, the part is going to be the smaller number. The T-bar, if we were to speak the T-bar of the language, what we're looking for is the part, what part of the whole? What percentage of this whole are we referring to? And generally speaking, the part's going to be the smaller number. We do have a case where the part is bigger than the whole, but that doesn't come. That's like the last math we do. So up until the end of this class, when we're looking at the variables, when we're looking at the components of the problem, the part is going to be the similar number. When we look at the T-bar, the lines mean something. The back fourth line right here means divide. The up down line means multiply. When we look at the T-bar, we are actually looking at three formulas. The T-bar allows me to solve for the part. It allows me to solve for the whole. It allows me to solve for the percent. I can only have one unknown variable. So I'm solving for one of the three. And as mentioned, the T-bar gives me three formulas. If your unknown variable is the part, then you take the whole times the percent. If your unknown variable is the whole, you take the part, divide it by the percent. If your unknown variable is the percent, you take the part and divide it by the whole. I typically think we have two options. We either get comfortable with, get familiar with the T-bar, or we got to know these three formulas as we get into like commission, for example. I encourage you to try the T-bar. I think if you can see the T-bar, if you can get the T-bar, guys, I'm not kidding when I say there's about 80% of this math that can be solved using the T-bar. The other 20% are just formulas that we just have to memorize. I encourage you to put all formulas on a flashcard. We got to memorize them. We got to know them. If you don't know the formula, you don't know the answer to this question, seriously, you might as well put B or C, whatever your favorite is, and just move on. If you don't know the formula, you don't have what you need to solve these problems. So let's talk a little bit about the part and whole. Let's talk a little bit about what we're talking about. Let's talk a little bit about, I'm such a fan of the T-bar, by the way, such a fan. As a matter of fact, I make it a personal mission myself to convert as many people to the T-bar during this class as I can. So I'll be interested to see in a minute if I already have fans after day one. If not, I'll get you, don't worry. But if we can just introduce you to it and kind of get you working with it. So let's say, for example, we're doing a problem about commission. And the problem tells you that the sales price, I'm just going to kind of make numbers up. The sales price is $100,000. You're going to get a commission of $3,000. And the question wants to know, what is your commission rate? I've read the problem. That's what we always do first. I've read the problem. I saw the word rate or percent. So I know, I may not know anything else at this point, but I know that I can throw down a T-bar. Where does the rate or percent always go? Bottom right. So can't we fill that in first? That's the one we don't have to think about. And quite frankly, in this case, This is my X. This is what I'm solving for. And now I'm left with two other scenarios. I'm left with the commission and I'm left with the sales price. Of those two, which one's going to be the smaller number? Unfortunately for us, which one is the smaller number? Our commission. Our commission is smaller than the sales price. So in T-bar verbiage, the commission is part of the sales price. The sales price being the whole, the commission is part of that. So I know my commission is $3,000. I know my sales price is $100,000. I have completed the T-bar. I have one unknown variable. I know the back fourth line means divide. So I take 3,000 on my not so smart calculator, 3,000 divided by 100,000. And on my calculator, I get a rate of 0.03. If I move my decimal over two places or multiply by 100, I get 3%. What is our commission rate? In this case, in this example, 3%. Part over the whole, the smaller number over the bottom, over the bigger number. So let's talk about a trick with the T-bar. This is why I like about it so much. I started doing math tutoring like back in 2011, 2012, something like that. I've been doing math tutoring for quite a while now. And in all my years, I got to tell you guys, the number one question I get in math tutoring is when do I divide and when do I multiply? And the T-bar allows us to address that. Because if you're ever concerned about when do I divide, when do I multiply, what do I put where? My solution to you is utilize the T-bar and do it both ways. In this case, I know I have nothing to multiply because I know that rate of percent always goes in the bottom right. Have you guys written that down yet? The rate of percent always goes in the bottom right. You shouldn't have to think about that. But now you're in the heat of the test and you're going, oh my goodness, I cannot remember. Does sales price go on top or does commission go on top? Oh, I don't remember. Well, we know the rate of percent always goes there. So now we're down to what to do with the other numbers. Instead of staring at a screen and waiting on numbers to manifest themselves and do something, I recommend to you guys with those other two variables that we're trying to do something with, play around with it. Play around with the T-bar. Keeping your unknown variable, it's still the unknown variable. But the other two numbers we can kind of play around with. Now, if I take 100,000 and divide it by 3,000, I'm going to get 33, a rate of 0.33. When I move that decimal over two places, I get 3,333%. Does it make sense for us to get paid 3,000% of the sales price? I mean, 3,000% of the sales price, we would just, we could sell one house and retire, right? We never have to sell another one. So my answer to you, if you're ever stuck, you can use the T-bar to help yourself get unstuck. All you have to do is remember that the rate or percent always goes in the bottom right. And then you may need to toggle, you may need to play around with those other numbers. I want to show another example using the same concept here, kind of. Let me kind of clean up a little bit. So let's say, all right, so we know we have that sales price of 100,000. And this time the problem tells us that the commission percent or the commission rate is 3%. And now the question wants to know how much commission are you going to get? Again, the rate of percent always goes where? We know the answer to this, right? So stay with me. The rate of percent always goes in the bottom right. Do that one first. You know where it goes. You don't have to guess. Do that one first. Now it comes down to, does my commission go on top or the sales price go on top? We know commission is smaller than the sales price. The up down line now means multiply. So we take 100,000 times 3%, and we get your commission of $3,000. But what if that 100,000 isn't in the right place? What if commission goes on the bottom left? I can't remember because I'm taking my test and there's a lot going on. Stop and breathe, and then give yourself, throw down 2 T-bars, and I'm telling you, try it both ways. Rate of percent's always going to stay here. Now, instead of doing 100,000 on bottom, let's just flip these numbers and see what we get. Now we're saying 100,000 divided by 3%. And I'm getting a commission of $3,333,033. To sell $100,000 house, does that seem reasonable to you? Unfortunately, does that seem unreasonable to you? And that's what I'm saying, you guys. The T-bar allows us to play around with the numbers now that we know that rate of percent always goes in the bottom right. Commission math is coming in Unit 8. We will do Unit 3, the end of Unit 3 next week. We'll do some property tax math. And I try to talk to everybody. I'll give you the T-bar because I do think it's the best tool we have at our disposal. I also try to give you the formulas when I can. Your book does as well. So if you're not a T-bar person, then you got to be a formula person. I got to have you as one or the other so you can get it. And again, I recommend please at least give the T-bar a shot, because I think once we get it, and it's so much easier. It allows us to move on without spending more time than necessary on the math. So now, knowing what we know, we already know the answer to this problem. But let's talk about Lane again. Only this time, let's talk about Lane with the T-bar. So we know that Lane's selling her home for $250,000. She knows that her firm's commission is 5% of the sales price. Now, this time when we read this problem, I've read the problem. All I need to do is see the words rate or percent. And once I see those words, for the majority of the time, I'm going to be able to use the T-bar. So we saw rate or percent. We're going to do that one first because we know where that goes. I also have Lane's commission, and we have the sales price. Commission is part of the sales price. Up down line on the T-bar means multiply. So we can take our sales price times the commission. And we can get, the commission rate at 5%, and we can get a commission of $12,500. Exact same thing we just did, but now we're utilizing it as a T-bar. There is a little bit of T-bar introduction back in the math facts section in the back of your book. They call it I think they call it an X-bar. Same thing, same idea. So you can get a little bit refresher there. The other thing I want to show you guys, as I mentioned the other day, I want to show you how you can grade yourselves when you take these, some of these practice quizzes, these flat practice quizzes, like the end of unit quizzes in your book, for example. Scattered throughout the online learning system, you may find some PDF quizzes. So I want you guys to be grading yourself so you know how you're doing, and you can use the T-bar to grade yourself. So what you're going to be solving for, the X, is going to be, your percentage, your score. The number on top is going to be the number you got right. And then the number in the bottom left is going to be the total number of questions in this quiz. Total number of questions. So let's say you take the quiz at the end of unit 2. And you went through the quiz at the end of unit 2. And you saw that you missed, let's say you missed 7. And you're going to ask yourself, is that good? Am I okay to miss 7 and still be able to pass a unit 2 quiz? Throw down a T-bar. Total number of questions at the end of unit 2 is 25. What did I just say? You missed 7. So 25 minus 7 means you got 18 right. You're solving for your score. 18 divided by 25 gives you a score of 72%. 75 is the minimum. Did you pass this test? You're close. You're close, but you didn't pass it. Everybody with me? So you can use this to grade yourself. The number you got right is part of the total number of questions. That's right. Close, but no cigar. 75 is what we're looking for. And honestly, you guys, I would strive for like 80 or 85%. Give yourself some wiggle room. So even if you got a 75%, do a mini woohoo, but you may want to mark that unit to go back because you're right on the borderline there. You're right on the cusp. So use the T-bar to grade yourself so you know where you are. I think if you guys are grading yourselves as you go, there should be no surprises on test day. But if you're not grading yourself, you're not gauging yourself, you don't know how you're doing, test day may be a surprise. T-bar 101. I just wanted to introduce you to it. I wanted to show you this tool so you guys can start practicing and grading yourselves. First time we're going to use it for real is going to be at the end of unit 3 next week. Questions on the T-bar? I love the T-bar. Do I have any T-bar fans yet? Anybody kind of like, oh, ooh, yay. Don't worry. Don't worry. If I don't have you yet, I will. Don't worry. Give me time. All I ask is that you give it a try. What's it hurt to try? And you try it and you hate it and it's the worst thing you've ever done in your entire life, then go back to memorizing the formulas. Fair enough? Questions? No more math today. Yeah. I have a question. I hear it on mute. Must be an accidental unmute. Let's see. I got Zoom power. So again, real math coming, the end of unit 3. We're going to get started on unit 3. I won't get through the whole thing today. Before we leave today, we're going to talk about what next week's going to look like. If you need to leave early today, remember, we don't have class on Tuesday. Please don't come to class on Tuesday. I'm not here to let you in. So you're going to be sitting there wondering why. Why is Julie not letting me in? Because we don't have class on Tuesday. So before we leave today, we'll talk about what next week's looking like and what we're gonna cover on Thursday. You guys have a great opportunity to get caught up, to look ahead, to make sure we're all going to be raring to go next Thursday. So unit 3 is addressing encumbrances on real property. So in this section, well, the first thing we need to do is define what the heck an encumbrance is. We're going to talk about things that encumber the property. One thing that encumbers the property are liens. So we're going to talk about different types of liens. Another thing that encumbers a property are easements. So we're going to talk about the different easements and how they may affect your property. Another encumbrance is property taxation. Every single property in the North Carolina is subject to taxation. So we're going to talk about those local laws, rules, taxation. And then the last piece of unit 3, we're going to actually calculate property taxes. We're going to figure out how to calculate your annual property taxes, for example. So with unit 3, all about encumbrances. And as mentioned, the first thing we need to do is figure out what an encumbrance is. An encumbrance is just anything that affects the title to real estate. It's not necessarily good or bad. We're not going to define encumbrances as good or bad. I don't know. I've never encountered a property that doesn't have some kind of encumbrance on it. So encumbrances are something that we just come across and we deal with. So they're not good or bad. Some are, some are. An encumbrance is just a limitation. It limits what we can do with the property, how we can sell the property, convey the property, for example, even if we owe fee simple absolute. Encumbrances are almost always appurtenant. What's an appurtenance? An appurtenance runs with the land. Remember our big fancy word from Tuesday? An appurtenance runs with the land. And most encumbrances are appurtenant, which means they convey. That's right, they convey from one owner to the next, and so on. So it's a right or interest of some type held by somebody that's not the owner of record. So we have several different types of encumbrances, and that's what we're talking about in Unit 3, are things that affect the title. By the way, title, deed, all that good stuff comes in Unit 5. So again, I just ask that you bear with me. So the first encumbrance we have in Unit 3 we're going to talk about are liens. When you have a lien, it means you owe somebody some money. You may want to write down lien equals loan. If you have a lien, it's because you owe somebody some money. It's a non-possessory charge against the property. It's a security agreement for the one that you owe money to. It's the only way these creditors have to protect themselves, to try to get paid on money that you owe them. Liens are recorded. The Register of Deeds are going to be public records. When somebody goes to buy a home, buy a property, they hire an attorney. An attorney does a very thorough search of the public records. And one thing in specific they're looking for are liens. The current homeowner is responsible for paying off these liens before they can convey. Anybody, where are my homeowners on the call? Did you use a lender? Did you borrow money from a bank or a mortgage lender to buy your house? You got a lien. And that lien will stay on your property until you pay the lender off. And that's the only way the lender has to protect themselves. That prevents you from selling the property out from underneath the lender. So the closing attorney does a search, they find the lien for the lender, and they say, before you can convey, you got to pay this loan off, this lien off. So they're going to be recorded. Again, recording, public records, all that's Unit 5. I call Unit 5 our attorney unit, as far as the attorney, the real estate attorney unit, and the things they're going to do, how they're going to help that buyer. So we have two different types of liens. In general, two types of liens. The first type of lien we have are specific liens. These are specific to the property. These liens are attached to 123 Main Street, and they remain on the property until they're paid in full. If you sell your house without paying off your lien, the new homeowner gets the lien, gets your home and your lien. See why buyers have closing attorneys, to make sure this is paid off? So you can start with a clean slate when you buy, when you own. So liens are specific to the property. They're appurtenant, and they're going to run with the property until they're paid off, until they're paid in full. We got several different types of specific liens. There's the deed of trust. North Carolina, we're awfully fancy. And in North Carolina, we just refer to the deed of trust as our mortgage. The deed of trust, that's what we owe the lender. Other states call it a mortgage. We're just fancy here. We give it a fancy name of deed of trust. Can spouses, parents put a lien on the property? Anybody that you owe money to can put a lien on the property. It's how they protect their interests. Remember our UCC agreement from Tuesday, that security agreement on the water heater? That's the only way that that creditor can protect themselves. They wouldn't have a lien, but they'd have a recorded interest to protect themselves. Another specific lien are real property taxes. As I said, all properties in North Carolina are subject to property taxes each year. We get taxed every year. Failure to pay taxes means they will put a lien on your property. If you don't pay them in time, they'll put a lien in the property. So when you go to sell it, they'll make sure that they get paid. We'll talk more about taxes. That comes back at the end of the unit. Another specific lien is government special assessments, not HOA special assessments, but government special assessments. Government special assessments, the government's improving the property. Maybe they're going to install sidewalks or street lighting. Maybe they're going to hook an entire neighborhood up to public water or public sewer. If they're going to improve the property, they're going to impose a special assessment on the homeowners. They're going to let the homeowners pay a part of those sidewalks, a part of the street lighting, for example. Real property taxes and government special assessments are referred to as our superior liens. I'm going to talk in just a bit about lien priority. Lien priority tells us the order that these liens get paid. Who's going to get paid first? Real property taxes, government special assessment. They're superior liens, which means they'll get paid first. Government makes the rules. Government's going to make sure they get paid first. I can't blame them. If Julie made the rules, do you know who I make sure would get paid first? Julie. So government special assessments, real property taxes, or superior liens means when we talk about lien priority, they will always be paid first. Another type of specific lien is a mechanics lien. We're going to talk about that next. Hang tight on that for just a second. And then the last one we have there is a North Carolina commercial real estate broker lien. Commercial agents, commercial firms may have the opportunity to file a lien on a commercial property to protect their commission. That doesn't say residential. That says commercial. This is commercial sales transactions only. Commercial sales transactions take a lot longer than residential. If you're selling your house, we go under contract, I can get you closed in like 35, 45 days. If you're selling your commercial property, we're going to get you closed in like 3 years. So commercial transactions, for example, commercial transactions just take longer, and this may be an option that the agent has to protect their commission. So let's talk about these mechanic liens. Specifically, mechanic liens are addressed under the North Carolina Mechanics Lien Law. A mechanic, as defined under this law, is anyone that provides supplies or labor to the improvement of the property. If you hire a contractor, if you hire a landscaper, an electrician, a plumber, if you hire a mechanic to come improve your property, and then you don't pay them, they have the right to file a lien to protect their interest. They have a right to file a lien to ensure when you sell your house, they get paid. All mechanics have the right to file a lien if they have not been paid. But specifically, the law specifically addresses projects that are $30,000 or more. If you're doing a project that's $30,000 or more, you have a lien agent. An example of a lien agent might be a general contractor. Think about a project that's $30,000 or more. You're like building a room on the back of the house, right? You're finishing the unfinished basement. I mean, this is a big project. You're not painting, you're doing something major, some kind of major renovation. And specifically anything more than $30,000 or more, we need to have that designated lien agent, that contractor. And the contractor is the one that coordinates with the painter, the electrician, the plumber, the sheetrock guy, right? The flooring guy, all those people that are going to come in and do that big project for $30,000 or not. A couple questions come in. Do they have to be licensed mechanics? Nope. Anybody you owe money to has the right to file that lien. If the owner dies, does any or all the type of the liens get transferred to the heir? They run with the land. So when you die, your heirs get your liens, and they got to be paid off before they can convey, before they can sell. So under the mechanics law, mechanics have some regulations. They have some stipulations, I guess we could say, that they need to follow. If the mechanic wants to file a lien in order to protect their interest, they must file the lien within 120 days from when they last provided the labor or the material. So let's say you hire a landscaper to get your yard ready for spring. They're going to come in and they're going to mow and they're going to trim the bushes and weed whack and and get you got, pine needles, and they're going to get you running, up and running for spring. Mechanic comes in, landscaper comes in, does their thing. You say, thank you very much. They go about to the next job and they send you a bill and you ignore it. And then they send you a second notice and you ignore it. And they keep sending you bills and invoices, and you keep file 32 in those things and putting them right in the shredder. At some point, the mechanic is going to realize this person's not going to pay me, are they? So they have a choice to make. They have a decision to make. And somewhere from the time they finish the job for 120 days, they need to file that lien to protect their interest. If they don't file within 120 days, then they've lost their right to collect. All they can keep doing is sending you invoice after invoice that we've already decided you're going to ignore. So the only way they can protect their interest is to file that lien within 120 days from when the work ended. Failure to file the lien means they've lost the right to stand in lien priority. They've lost the right to collect. The mechanic also has the right within 180 days of finishing the job to bring action to enforce. Anybody you owe money to can foreclose on you. And if the mechanic wants to take that action to enforce, they want to take your property to collect their lien, they have to bring that action to enforce within 180 days of it finishing. And we're going to talk about a few examples in a second. Guys, I'll be very honest. Most landscapers, most mechanics are not in the business of foreclosing, but they have that option. So they file the lien within 120 days. If they choose, they bring action to enforce within 180 days. And it's all based on when the work ends. It might be a 2-week project. It's not when it begins, it's when it ends, when it's finished. I mentioned earlier about lien priority. I got more to say about lien priority. Lien priority tells us in what order everybody's going to get paid when you go sell your house. With lien priority, I imagine all these creditors standing in line with their hand out, going, sweet, I get my money. And lien priority tells us what order those people are standing in. I will talk more about lien priority in just a second, but right now, while we're on mechanics liens, all liens are going to be paid in the order in which they're recorded. So it comes down to a date and time stamp at the courthouse. The first one to record is the first one that's going to be paid. And these lien priorities tells us who's standing in what order, who's going to get paid first, who's going to get paid second. Liens are paid in the order in which they're recorded, except for the mechanics lien. Mechanics lien is the only one that's retroactive. It goes back to the day the work began. The day that that mechanic showed up and started offering you supplies and labor, that's where they're laying priority. That tells them where they have the right. So if you have this big project where they're building the room at the back of your house, this could take a month, right? And we're trying to determine in what order that mechanic's going to be in. They're going to be placed in line in the order in which the work began. So all liens are paid in the order in which they're recorded. Superior liens are always first. All other liens are paid in the order in which the work was recorded, except for the mechanics lien. The mechanics lien is paid in the order in which the work began. So I'm going to talk more about this. We're going to talk about an example mechanics liens, and we're definitely going to address that lien priority thing a little bit more. We need to take a break though. So let's take 10 and we come back. We'll talk more about these lien priorities and how this works. We're back. How we holding up for the last hour? Doing good? Good, good. I just finished a night pre-licensing class. That last hour was from 8:30 to 9:30 p.m. Whew, that last hour was tough. At least we're a little fresher, right? But I will tell you guys, like I told them, I understand this last hour, you've been staring at the screen for like 3 hours now. If you need to get up and stretch, if you need to get up and move around, I'm okay with that. Just stay within the frame of your camera. So if you need to get up and get some blood flowing, whatever, I know the last hour can be tough. All right, cameras are on. So let me take attendance. And a little bit more to say about these mechanic liens. So we've talked about lien priority. Great question comes in the chat over break. Let me go back up and find it. Yes, Pierre, I can. Okay, so would the homeowner pay the balance from the lien to the courts or to the mechanic directly? So let's say a couple months from now, you say, oh my gosh, I forgot to pay that mechanic. He sent me invoice after invoice and I just forgot. Guys, you may or may not know that you have a lien on your property. You may not find out that you have a lien on your property until you go to sell it and the closing attorney notifies you, right? We got to get this taken care of. If you pay that mechanic or when you pay that mechanic off, the mechanic should file what's referred to as a deed of release. And that deed of release releases you from the mechanic's lien. Should the mechanic not file that deed of release, the suggestion is that you keep your paid in full invoices. So when you do go to sell and it comes up, you have that proof that you paid that. The attorney would be up to the one then to verify that it was taken care of. So as soon as you remember you forgot to pay that mechanic, go ahead and pay them. And then you'll have that paid in full invoice that will kind of show that it's paid. It's taken care of. So then the attorney can handle clearing that up.
I have a question.
Yeah.
Julie. What if I'm ready to sell the house?
So you as a homeowner, you could hire an attorney to do a title search for you to find out if you have any liens, as opposed to being surprised when the buyer finds them, if that makes sense. So you could at any time get with an attorney and, say, hey, I have a question, do I have liens? And then they can do that. So if you know you're getting ready to sell and you don't know that if you have lien, that may be one thing to consider. Absolutely. So would the mechanic just take the invoice to the court? No, they would file a deed of release. Deed of release releases you from the lien. So it's a different filing. And they have to go through an attorney. The attorneys are the ones that file down at the courthouse. Yes, ma'am, Jennifer.
Now, what if you don't know about the lien? Do they get their money eventually, or how do they
So
go about that?
we're getting there. Hang on just 1 second. Just
Okay.
1 second. Yep. So with mechanics liens, let's put your pencils down for a second. Is you guys' hands hurting yet? Put your pencil down for a second and let's just talk through a couple examples, a couple scenarios about these mechanics liens. And they're 120 days to file and they're 180 days to file. And remember, mechanics liens are the only ones not paid in the order in which they're recorded. That mechanic will be paid in the order in which the work began. So let's say on August 8th, your water heater goes out. The water heater guy shows up, replaces your water heater, all on the same day. It goes out, you get him here, you get a new water heater, all on August 8th. And then you neglect to pay that guy that gave you hot water again, right? So you didn't pay him for whatever reason. They have 120 days to file the lien. Now you may have an agreement that says, paid within 30 days, pay within 60 days. So that's why it gives them 120 days, gives you time to send that in. The mechanic's deadline to file the lien, roughly 120 days from August 8th, would be on December 8th. After December 8th, they've lost the right to file the lien. On December 9th, they can't file the lien, they can't collect via lien. The 180 days says that they have 180 days from when they did the job to take action to enforce, to bring action to foreclose should they choose. Now, let's say August is a really bad month for you. 2 days after your hot water heater goes out, your AC quits working. Guy shows up, says this is what we need to do to fix it. They come out, fix your AC, and the work is complete. Remember, the 120 days, the 180 days starts from when the work ends. So in this case, because the project ended on August 16th, their 120 days is roughly December 16th. Their 180 days is roughly February 16th. These are the mechanics deadlines for either to file the lien or to bring action to enforce. So let's say you don't pay either one of these guys. They give you hot water and they give you AC, and you don't pay them. The AC guy files his lien on November 20th. The water heater guy files his lien on December 1st. Set your chats to private. And I would like you guys to tell me in a private chat which of these mechanics will get paid first. So who's going to get paid first? Is everybody in? Who's going to get paid first? The answer is the water heater guy, because mechanics lien is the only lien. It's not paid in the order in which it's recorded. It's paid in the order in which the work began. Who began their work first? The water heater guy. Does it matter that the AC guy filed first? They both filed within their time frame. They're both good. Mechanics liens are the only liens, perfect. Mechanics liens are the only liens not paid in the order in which they were recorded. Mechanics liens are the only ones paid in the order in which the work began. I love seeing light bulbs click on. I love it. Does that help? Did that example help? So specific liens are one type of liens. Specific liens are specific to the property, and they're pertinent to the property until they're paid in full, until they're paid off. The other type of liens we have are general liens. These attach to the people. These attach to the person, and they will follow that person until they're paid off. So if you go to apply for a home loan, if you go to apply for a car loan, if you go to apply for any kind of loan, general liens will pop up, and you may or may not get a loan until you get these paid off. A couple different types of general liens. The first type of general lien is our judgment. Again, if we can see a little play on words here, within judgment, can we see the word judge? A judgment comes from the court. A judgment is a court order. Somebody's taken you to court, and it's been determined that you owe them money. So the judge may file a judgment, a general lien that's going to follow you everywhere you go until you get that paid off. Failure to pay tax on your personal property. Personal property taxes are on things like the cars, the boats, the RV. Failure to pay your personal property tax lien could result in a general lien. Failure to pay any of your state taxes. So for example, unpaid income taxes would be a state tax lien. Inheritance tax, if you inherit a property, they're going to tax you on it. Failure to pay that could result in a general lien. And then federal tax liens, failure to pay the IRS could result in a general lien. When you go to sell your home, if you have any general liens, if you have any specific liens, they're going to come up when the attorney does a search on behalf of the buyer. And you're going to be required to pay those off. If you go to apply with general loans, if you go to apply for a new loan and you have a general lien out, the lender's going to say, you have a judgment, you have a court order, you have state tax liens, whatever. You have something that's preventing you from getting more money because you haven't paid off that money yet. Does that make sense? These are things that are going to come up in like your credit report, credit search when they're trying to determine if they can give you money. So let's talk about this lien priority. Lien priority tells us the order that people are standing in waiting to collect their money. When you go to sell your house, everybody lines up. They're like, sweet, time to get paid. And lien priority tells us what order they're standing in. Superior liens are always paid first. There's another absolute word there, isn't it? Superior liens are always paid first. Any unpaid real property taxes, I should say outstanding real property taxes, government special assessments. Following superior liens, all liens are paid in the order in which they're recorded, except for the mechanics lien that's paid in the order in which the work began. So you're going to sell your house, and all these lien holders are standing in line with their hand out. The government's first to collect their taxes and the government special assessment, followed by your outstanding liens. You know who's at the very end of that line? You, the homeowner. Your proceeds of the sale of your home is after you pay off those outstanding liens. After you pay out the cost of the sale to sell your home, attorney's fees, commission, all those things that we will address, all those things, all those people that are waiting to get paid from the sale of your home are all ahead of you. The homeowner is the very last one, and guess what? You get what's left. Have you guys ever heard of a homeowner being underwater? What we're referring to with somebody that's underwater, it means that they owe more than what they can sell their house for. They have more people standing in line than what they can sell their home and pay it off. Filing a lien only gives you a place in line. There is no guarantee that there will be enough money left over to pay you. Does that make sense? So filing a lien is not a guarantee you'll get paid. Filing a lien only gives you a place in line. It gives you a shot. But guys, bottom line, if the money runs out, there's no money left to go, the seller won't be able to convey. One thing we're learning, when the buyer buys, they're taking the property under a clean slate. All those liens have to be cleared. All those liens have to be addressed. So when the buyer buys, they're starting their own lien priority. The seller will be responsible for paying everything off before they can pass that clear marketable title. And if they can't do it, then we might be looking at foreclosure. We might be looking at short sales. I'm going to talk about both foreclosures and short sales. We have a couple financing units, so we're going to talk about those when we get to 14 and 15. But there's the only money we have to divvy out is that of the sales price. And when that money's up, that money's up. So when we talk about the seller's proceeds, as we're starting to introduce you to some of these terms, when we talk about the seller's proceeds, we're saying that's what the seller gets after all those other people Like I said, that doesn't only include lien holders, but they got to pay the attorney, they got to pay the agent's commission, they have other costs as well. They are the very last one, and they get whatever's left. And if they can't do it, then we got to look at some other options such as foreclosure and short sale. That's what we mean by lien priority. Specifically, especially with the mechanics. All we're doing is giving you a shot. If you don't file the lien, you don't have the right to stand there in line. Does that make sense? What questions do I have on lien priority or liens? I want to lien on a home. Can you sell the home? No. You have to pay it all off before you can convey. Seller has one job when they're selling their home, and that's to pass clear marketable title. And if you can't pay it all off, then you cannot pass clear marketable title, and you might be looking at a foreclosure or short sale. Where does title insurance come into play? We're going to talk about that. Title insurance protects the new owner. So let's say, for example, let's run through that as a scenario. Let's say you decide you're going to sell your house, and the agent shows up and they say, and you look at the agent and you say, what can I do to make my home more attractive, to make it more appealing? And the agent says, well, maybe get a landscaper out here to take care of your front yard. You say, great, I'm going to hire the landscaper. They come out, do their thing, make your front yard look really pretty, and then you never pay them. And then you sell your house. And then the mechanic files the lien. What is the lien attached to? That's a specific lien that attaches to the property. The new homeowner, the buyer, the new homeowner could have a lien on their property that they didn't even acquire because of the seller. Title insurance is there to protect that owner, to protect the new homeowner. Title insurance will say, there's no way that the attorney could have found that unpaid lien because it wasn't recorded until the buyer bought. So title insurance is there. I always say title insurance protects the current owner from errors of the past. Can we trust all sellers? I wish I say we could, but the truth is we don't know, right? So they say, oh yeah, I paid it, no problem. If that lien pops up and we can prove that that was a lien from the previous owner, that's why we have title insurance. And title insurance covers you for as long as you own. So if you own it for 2 years or 20 years, it's going to cover you for as long as you own, as long as it's covering that error of the past. There's no way the attorney could have found it in the public record search because it wasn't even filed yet. Again, title insurance, recording, deed, title, all that good stuff is coming up in Unit 5. So we'll get a little bit more in depth into that. So liens are an encumbrance. They're an encumbrance because they affect the title. You can't pass the title with any unpaid liens. So liens affect the title. Liens are an encumbrance. Another encumbrance we may find on a property are deed restrictions. These are restrictions listed in the deed. Remember our fee simple defeasible? Those would be a deed restriction. Those are going to encumber the property. If you're in an HOA, you're going to follow some kind of covenant. Now we call these things restrictive covenants, protective covenants, CCRs. It's one of those things that we got several different words for. Covenants are the law of the HOA, the rule of the HOA. So if you're in a subdivision or community with an HOA, they're typically covenants. Those covenants are going to be deed restrictions. They're going to be restrict how we use the property. Again, more on that in Unit 6. Deed restrictions also need to be on public record. So the attorney, you and I can find them. Y'all know what public record means, right? Who can access the public records? Anybody, the public. My homeowner's on the call. Did y'all know your deed could be found online by anybody? Did you know that? Don't do it now, but what you might want to do at some point this weekend is go to your county's register a deed website, whatever your county is, register of deeds, and you poke around enough, you could find your own deed. Isn't that something? It's out there for the public. Same thing with these liens, same thing with these deed restrictions. This is how the attorney can find them to assist that buyer. Deed restrictions, again, usually created by the developer, the original owner. So if you do a fee simple to feasible, you would be the owner that put a restriction on your deed, and that is public record. Another encumbrance, something else that could encumber your property. We had a French lesson earlier, right? Now it's time for a Latin lesson. Lis pendens. Lis pendens is Latin for litigation pending. If there is an encumbrance of a lis pendens on the property, it's like a legal stop to the public. And what they're telling all interested buyers, do not buy this house because we are in the throes of a lawsuit. There's a pending litigation on this property. Don't buy it, because at the end of the lawsuit, if the owner loses the property, then it's no longer the owner's to sell. So it's a legal stop. It's a legal warning that there's a pending litigation, that there's a lawsuit going on. And depending on the outcome, it may affect who can convey the property. Another encumbrance is called a writ of attachment. This is another court order. This is another legal stop. But with this one, the judge has taken the property. We just haven't gotten it out yet. We're just still in that process. If the judge has taken the property, they're not going to themselves go take it, are they? They're going to send the sheriff. They're going to send the sheriff to seize it. So the sheriff has been given the go-ahead. Again, you guys, we're trying to prevent the unsuspecting buyer from buying it from the shady seller. We don't want the shady seller trying to sell it out from underneath. The court has taken the property. We're just waiting on the sheriff to do their thing. Both lis pendens and writ of attachment are legal warnings, and they're going to be on the public record to let all potential buyers know. Hold up, don't buy this. Something's going on. Something legal is going on with this property. Another encumbrance, and one I'm sure we've all heard of, are easements. I don't know many properties that don't have an easement on it. Who here likes your electricity? Who likes your water? Who likes your internet connection? You got some kind of easement. Unless you're totally off the grid and you generate your own power and you have a well and you somehow get your own internet, you have some kind of easement to give permission for that water to get to your house, give permission from the electricity to get to your house. Those that have an easement have no possession interest in the property whatsoever. We're not giving you ownership. All an easement is giving somebody else permission to use your land for a pretty specific purpose. They don't have permission just to show up whenever they want to, but they do have permission to show up when they need to take care of their plumbing or their electrical or whatever it is of theirs that's on your land. So an easement is just permission to use another's property. We have two types of easements. The first type of easement is an appurtenant easement. What do we know about appurtenant? It's an easement that what? It runs with the land. It's going to convey from owner to owner. With an appurtenant easement, it affects two and only two adjacent tracts of land, neighboring tracts of land. Appurtenant easements are never more than two. If they are, we're dealing with the other type of easement that we're getting to. So with an appurtenant easement, two different adjacent lots of land appurtenant easements are going to be appurtenant on both tracks, which means when you go to sell, that easement's not going away. When your neighbor goes to sell, that easement's not going away. There's a great picture of an appurtenant easement in your book on page 57. And you can see we have lot A and lot B. Lot B needs to access the road. And they can't get through those trees. Maybe those trees are protected. Maybe there's a zoning that protects those trees, a tree save. So lot B can't access the road unless they go on lot A's land. These are both appurtenant easements. Both tracks have an easement. The easement that's running over, in this case that we're looking at in our book, lot A, that is the servient tenement. That is the one being used. The tract of land that benefits from the using, the one that does the using, back to our book, is lot B. They are the dominant tenement. So the servient is being used. The dominant is the one doing the using. We're going to see in just a bit, or next week, but we're going to see soon, you can't land lock somebody. So pertinent easements are often created. Again, these trees, I'm guessing, are protected. It's not like you can tear them down and build a driveway. So the only way lot B can access their property is to use lot A, that appurtenant easement. I think where we see easements created the most, I'm going to try to draw a picture. I'm not much of a drawer, but bear with me. So let's say we have a tract of land and the road is right here. So we have the tract of land, and let's say you own this tract of land. And you wake up one day and you say, I'm going to subdivide my land. I'm going to take my land and I'm going to split it in two. And you decide to subdivide it. I don't know why, but you decide to subdivide it this way. And you say, well, I'm going to live here and I'm going to sell the back part of the land here. You can't landlock B. You have to provide an easement to allow B to access the driveway so they can come and go. Who owns the driveway? A. Who's responsible for maintaining the driveway? A. Whose driveway is it? A. Could A ask B to help in repairing the driveway? Hey, man, we got potholes. You want to help me repair this? Can A ask B? Sure. Is B under any obligation to help you repair your driveway? No, because it's not B's. All they're doing is using. All they're doing is giving you permission to use it. I actually showed a house once in B. I got an opportunity to show this exact same scenario, and the house we showed was on lot B. And explaining to this buyer, there's an appurtenant easement. You see that, and y'all, that driveway was rough. I mean, it was rough. I almost needed a four-wheel drive to get down, but we got down. And in explaining this to that buyer, Like when you buy, you don't own a driveway, you don't own that land. But there will be an easement, it's appurtenant, there will be an easement that will give you permission to come and go. Again, you can't land lock somebody. You can't prevent somebody from egress or ingress, coming or going. Sounds like a good call to an attorney. Another example of an appurtenant easement could be that party wall that we talked about. It's just something that's shared. Both parties have an interest. What about a shared driveway? If you have a shared driveway, like in a downtown area, both of these homeowners on the left and right here would have responsibility for that driveway. You draw the line right down the middle. You see the party wall of the garages. Safe to say you could draw that line right down the middle. And if we get a pothole in the middle, then we would both need to address it. But the appurtenant easement, it's appurtenant, meaning it conveys from one owner to the next, to the next, to the next. And show me, everybody show me, how many tracts of land are affected by an appurtenant easement? Everybody show me, how many tracts of land? 2, and only 2, never more than 2. Could there be an encumbrance filed on the deed for a driveway maintenance? Of course. Could there be? Of course. Of course. And we would file the whatever the agreement is, however that's created. So an appurtenant easement, that's true, 2 tracts of land. We're going to talk about creation of easements. I may not get to them today. We might be cutting it close, but if we don't get to today, we'll talk about it next week. So the first type of easement we have is a appurtenant easement. The second type of easement we have is called an easement in gross. Maybe an easement in gross affects 1 tract of land. Maybe an easement in gross affects thousands of tracts of lands. With an easement in gross, somebody or entity has the right to use the land. I'm going to come back to personal easement in gross in just a second, because I think the more commonly known easement in gross is the commercial easement in gross. Commercial easement in gross is what gives Duke Power the right to come on your property when they need to tend to their power equipment, their power poles, whatever they have on your property. Another good example of commercial easement in gross is if you have railroad tracks that run maybe the back track of your land. R&R Railroad would have that commercial easement in gross that would give them permission to run their trains up and down the track. It would give them permission to come on your land and fix their tracks should they need to. You can't stop a train, right? So it's not like you can go out there and hold a sign up that says, don't drive your train across my yard. They have permission to do so through this easement in gross. The power company, R&R Railroad, this commercial easement in gross comes with a court order. So again, Duke Power is not knocking on your door and saying, can I have permission to put a power pole up in your yard? That comes through the courts. It's a recorded easement. So when you buy property with an easement in gross, you know that there's an easement in gross on it. Now, here's the thing about easement in gross, they're not appurtenant, which means when the easement owner dies, let's talk about Duke Power. If Duke Power dies, that means they shut their doors or they sell to another power company. That easement in gross is not automatically transferred to whomever purchases Duke Power. Now, whomever is purchasing Duke Power is going to have really good attorneys to make sure when they buy Duke Power, they also acquire their power lines and their power poles. So a new easement in gross would be created with the new power company. So they can make sure they can come on your land and tend to their equipment. You guys hear on the news every once in a while, a homeowner is all upset because the city came on their property and accessed their equipment, accessed their electrical box or whatever. And they're going to go file an attorney and complain and talk to the news and da 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 da. If the power company has an easement in gross, a commercial easement in gross, then they have permission to come onto your land and tend to their electrical box. The personal easement in gross could also be granted. Again, they do not run with the land. So personal easement in gross would just be granted from the homeowner for as long as they own it. Let's say, for example, you have a whole bunch of land, and on your land, you have a really nice pond, and your friend decides they want to fish on your pond. They may request a personal easement in gross, which would give them permission to come fish on your pond whenever they want to. And if you grant them that, you can't go back and take it back. You can't say, no, 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 you can't come fish on my pond. If you choose to grant your friend, your buddy, that personal easement in gross, that as long as you own the property, they can come on your land and fish on your pond. You've given them permission. When you sell the home, they no longer have that right because they're not appurtenant. And when you sell to the new owner, if your buddy comes and fishes on the pond, now that's called trespassing, unless they get permission from the new owner, unless they get that personal easement in gross. Do you have to grant your buddy that permission? Do you have to give them that personal easement in gross? No, you as the homeowner have that choice. But if you do, no, you can't take it back. You've given them permission for as long as you own that property. And after you sell, if they want to come back and fish, they need to talk to the new owner. Another good picture, let's see, page 58. We see our easement in gross addressing our power lines. Lot A has a whole bunch of power lines on their property, don't they? Lot B only has a few. I mean, think about railroad tracks. How many miles do those things cover? So whenever we see railroad tracks, power lines, anything like that, we're very well dealing with the easement in gross. Questions on that? I got to go off book for a second because I want to introduce you guys to a couple words. And we need to take time to make sure we get these words because we're going to see these words pop up several times. We're getting ready to see them and talking about easements. We're going to see them when we talk about agency, contracts. We're going to see these words pop up. So I want to take a few steps back and have a conversation about these words so we can have an understanding about them before we apply them to an easement. And the words I want to introduce you guys to is express versus implied. If you have something that's express, an express agreement, for example, express means that the terms have been clearly stated. We know what's going to happen. We know this agreement. And maybe those terms were stated verbally. Maybe those terms were stated in writing. Doesn't matter. What matters is that the terms were clearly stated. We now know if you state those terms verbally, what are you going to do? Document, 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 document. So what do we document? Everything. An express agreement, again, doesn't care, doesn't matter how the terms were stated. An express agreement just says that the terms were clearly stated. Compare that to an implied agreement. We didn't state the terms. We just started acting like we had this agreement. We didn't talk about what it meant. We didn't have this in writing. We didn't have these conversations. We just started acting like we had had this conversation. I think a great example of something that's implied. Who's going out to dinner tonight? You're going to go out to a restaurant, going to sit down, a few of you. So we know how going out to dinner works. You go to the restaurant, you sit down, the server comes over and takes your order. They put your order back in the kitchen cooks your food. They bring it out to you, you eat it. When you're done eating, you pay your bill, right? That's an implied agreement. If it were express, when the server took your order, they would say, now you're going to pay for this, right? But it's implied that when we order food at a restaurant, we're going to pay for it. Nobody had to say that. Nobody had to spell it out. It's implied. We know how to act in a restaurant. So now taking these words again, we're going to see these over and over and over and over again. I need to count one time how many times these pop up. So now that we have an express versus implied, let's bring these back into our creation of easements and how easements are created. They can be created one of three ways. An express easement means that the terms have been clearly stated. We have spelled out the terms of this easement. If we want to solidify it, we will put that agreement in writing. But the terms have been clearly stated. An implied easement is created as the result of a surrounding circumstance. An example of an implied easement is called an easement by necessity. I'm not going to be able to say that word. Necessity. There, I did it. An easement by necessity. The implied easement is the one that we just said you can't landlock somebody. If you're going to subdivide your land and you're going to sell the back of the tract of the land B, it's implied that they will have access to the road. Necessity, easement by necessity. The third way that easements can be created is operation of law. The judge could come in and create an easement. If Duke Power wants poles on your property, if R&R Railroad wants railroad tracks, they're going to go through the courts. Again, R&R Railroad is not going to come knock on your door and ask you permission. They're going to handle this all through the courts. Another example of an easement created by operation of law is something called an easement by prescription. With an easement by prescription, somebody has been using your land and they've been using it for long enough, say for example, 20 years, and they now want to go to the courts and ask for permanent permission to use your land. What they're asking for is an easement by prescription. They can go to the judge. They can say, I've been using this property for 20 years. Just grant me permission. Grant me permanent permission. And if the court decides they have granted an easement by prescription. Remember, an easement is just giving somebody permission to use your land. When we get to Unit 5, yeah, I'm sorry.
And in that case, does it matter per homeowner? So it's like, for instance, this person owned it for 10 years and the other person bought it. Now they owned it for 10 years and there's history of that property. Does that count in the 20 years?
That's a great question, Regina. I'm not sure the answer to that. What I understand is the claimant has been using it for 20 years. So they've been using it from the same homeowner, or if we had different homeowners, I honestly don't know the answer to that. That's a great question. But what we need to know, the claimant's been using it for so long that they're just going to the judge and they're saying just, and now if they're going for a permanent easement, then that's going to affect the other guy, right? So that may depend on who, how long they've owned. But the claimant's been using it continuously. And so now they're going to go ask permission. When we get to unit 5, we're going to take easement by prescription a step further. And when we get to unit 5, we're going to talk to you about something called adverse possession. With adverse possession, somebody's going to the court and saying, I've been using this property for 20 years. Give it to me. You could lose your property or a portion of your property through adverse possession. Easement by prescription is just permission to use it. Adverse possession is taking it a step further, and now you're wanting the courts to give you that property. So we'll see that when we get to unit 5. Real quick, I am watching my time. Just one more thing to say about easements is how they end. I'm on page 59. Terminating easement, cessation of purpose. If the reason why the easement was created no longer exists, then that would terminate the easement. So for whatever reason that easement was created, that purpose no longer exists. Merger of the parcels. Remember, you subdivided your tract of land. You had owner A and owner B. If you were A and you bought B, you have now merged the two. You now own that whole tract of land. You've merged them. The purpose of the easement has gone away. You could release somebody from the easement. Again, in our book, we saw that example with the trees and the driveway around the trees. If they lifted the tree save, then that would release the easement because now you could build your own driveway. Or if the easement was abandoned, if they stopped using it altogether, then after a certain amount of time, it would just kind of go away. So next week, let me stop sharing so we can have a good eyeball to eyeball conversation here. Where are you guys? There you are. So next week, no class on Tuesday. Everybody good? Use Tuesday to your advantage. Use Tuesday morning. You know, we don't have class. You know, typically Tuesdays and Thursdays, we're going to be here from 9 to 1. I encourage you, we just started, so we're not ready for a break yet. But I encourage you to use Tuesday to get yourself caught up, to get yourself read ahead so you can be with us when we come back together on Thursday. So we're going to go a whole week without seeing each other. Awesome. I'm getting there. On Thursday, and remember, we have our tentatives. You guys give me just 1 second. I do wish I could open my mouth. You know what I wish? I wish I could sell you a magic pill that could give you all this information at once and I wouldn't have to stand there saying like, you know, but the truth is if I had that magic pill for sale, I wouldn't be here. I'd be out on the street selling my magic pill. So give me just 1 second. On Thursday, as per our tentative schedule, we're going to finish unit 3. We're going to do the math at the end of unit 3. If math isn't your thing, I encourage you to look ahead. Look at the end of unit 3. There's a section called math concepts. So look ahead, introduce yourself to the math that we're going to see. After unit 3, we'll do unit 4. After unit 4, we might even get started on unit 5. Unit 4 also has math, but I'm not going to do 2 maths to you guys in one day. So we'll do unit 3 math, and then we'll hold off on unit 4 math until the following week. It'll take us no time to get through the non-math piece of unit 4. So we very well will get started on unit 5 as well. Once you've looked at unit 5, keep going. Why stop there? Remember to refer to our tentative schedule to know about what we're going to cover when. So Thursday, let's see. Is there a certain amount of time that has to pass before the easement is lifted by the abandonment? I'm not sure about that. That might be a judge thing, you know what I'm saying? But I don't think there's not a stipulated amount of time. It more be of a situational. All right, you guys. Today's video will be loaded, like I said, about the time you eat dinner tonight. So you can go back and review. As you guys are studying this week, please don't hesitate to reach out to me. Let me know if there's anything I can do to help. Send me screenshots of questions you're stuck on. Remember to use me as a resource. Let me know if I can help. Otherwise, you guys have a great week, and we'll see you next Thursday, 9 a.m. sharp.